Councilmember Babcock.
Present.
Councilmember Brookover.
Here.
Councilmember Watson.
Here.
Mayor Pro Tem Gregg.
Here.
Mayor Bacon.
I move we approve the agenda. Second.
So moved by Babcock, seconded by Councilperson Watson. The meeting is open. Let's go with the first. Who's up first?
I'm sorry, I can't hear you guys with the fan going. I just,
Oh, yeah, we're all gonna have to the mics thing.
Yeah, I call him that, Jessica.
Looks like our first firm presenting is Casey Conklin PLC.
Evening. Good evening.
Hi. And as it was just pointed out, we have a little background noise, so we
Yeah.
can project, that would be
And
most appreciated.
The first word I heard from you guys was when you said my name, so. All right, so I'm Casey. I brought with me one of my contract attorneys, Ashley, and my associate attorney, Colin.
Very nice to meet y'all.
And you guys got our bid, so you know a lot about us. But if you have any questions, please let me know. We're a small firm based out of Okemos. I live here in East Lansing. In fact, I live about 2 minutes away. All three of us attended Michigan State, so
Yep.
we're familiar with the area. We're a general practice firm, but our area focuses mostly around business and estate planning. Ashley and I both work in counseling, so estate planning and business counseling and also tax counseling. And Colin is a litigator who focuses on employment issues.
Employment, civil rights, constitutional claims, things of that nature.
And my background also, I have a lot of experience with real estate, real property law. I've done some zoning use work on behalf of private clients. So the kind of the municipal type work on behalf of private clients.
Yes, just organically addressed question number one. Are you satisfied with that? For the question?
Can we read it out loud though, just in case they have?
Yeah.
Absolutely.
Thank you.
Consistency.
Yep, so number one, you reviewed your application. Please briefly tell us about your background experience. You started as city attorney for the city of East Lansing. Question that leads right into your satisfaction. That leads right into question number two. Who would serve as lead city attorney? What would be their response time and availability?
So I would be the lead. My response time would be fairly quickly. Like I said, I live literally right down the road. My backyard looks at Bertram. And I'm available 24/7 via my cell phone. The only issues that ever might come up is I have two small children, so it would be childcare. But other than that, I'm fairly available.
Anybody go for
So our number three is our diversity question. Diversity, equity, and inclusion are not just words in the city. What racial justice work has your firm been involved in? How does diversity show in your firm? And how does inclusion matter?
As far as diversity in our firm, like I said, we're a very small firm. There's 4 employees and 3 contractors, so there's not a whole lot of room there. We have 3 females. My office manager, my paralegal, and Ms. Prue here. What's that?
I'd like to answer this too a little bit.
Yeah. As far as the rest of the questions, I'll defer to Ashley and Colin.
So I have experience also with chambers of commerce, and I'm on the Howell Area Chamber of Commerce, and we are recently forming a diversity, equity, and inclusion subcommittee, and I'm actually a member of that, and we are working to, Howell, as you may know, has some racial issues in their history, and we're working to overcome that. Unfortunately, our board in that area doesn't have a lot of diversity on it. There's also not a lot of diversity in Livingston County, but I've tried to do a lot of work to bring to the extent possible, more diversity to the organizations in Howell specifically. I was also on the search committee for their hiring for their president, their executive director, and while our candidate, we didn't have any candidates apply of racial minorities, we hired a woman, and I know she is very oriented with the DEI inclusion as well. So that's the extent of my experience in those programs. I don't purport to know everything about it, but very supportive and trying to bring that to community organizations specifically.
And from my aspect, the largest part of my practice is discrimination claims. I've handled claims under Title VII. I've handled fair housing claims. I've certainly, walked the walk and talked the talk about helping people that have been victims of discrimination seek justice and recompense for that. And I have 10 years of experience handling such claims.
Yeah, just keep
May I ask a follow-up question?
Absolutely.
As long as we are conscious of our time to get through our.
But
Yeah.
we'll set the standard here for us. We'll retain most of our follow-up questions to the end because we want to give them a fair shot, get
There we go.
their questions.
Thanks.
And then we'll bring you all the follow-up questions at the end, and if there's extra time, we'll allow you to put in any additional stuff or whatever we can use the same questions.
Sure.
Thank you.
Okay, get to number 4. And what is the amount of time?
I think we were hoping to keep everybody to about 45 minutes.
Approximately, yeah.
Or less.
Or less.
Or less, right.
Don't feel any
Very
pressure.
well.
We'll talk fast.
Yeah.
Great efficiency.
We get it.
Number 4, as city attorney, you must have a good understanding of the city charter and city ordinances. There's 2 parts. A is, do you believe that it is important to enforce the city charter and ordinances even when enforcement may be contrary to an outcome desired by the city council or city staff? And B is, using the city charter as your guide, what is the nature of the relationship between the city council and the city attorney, the city council and the city manager?
So as far as the charter and the ordinances, that's basically what we do daily. Ashley and I, working with businesses, we have to abide by the bylaws of the business, not the state statutes, not the federal guidelines per se, but the bylaws trump a lot of those. And so we are used to working within those guidelines. And everything can be interpreted differently. And so we try to nail down what was meant by the team that wrote it whenever those bylaws or those articles of incorporation or whatever it is were written. And so we're, that's what we do on a daily basis. I represent right now 3 associations, a couple of trusts, and all those are guided by their bylaws. No matter where we land on what the issue is, the bylaws determine what the outcome is going to be. And then I'll let you guys follow up if you have anything else.
Well, in respect to the question, would that be contrary to a desired outcome by the city council? I think if we're coming into a situation where we're at loggerheads with what we want to happen and how the ordinance reads, we'd probably want to address how the ordinance is written at that point. But when it comes to a present instant case in front of you, boy, varying from that, you're just opening yourself up to all sorts of due process litigation and potential claims for discrimination if you're not following the ordinance. The best thing you can do is follow what you've written.
That's what I was going to say, is you have to be consistent. You can't have a desired outcome for one potential situation and not the other. And also, regarding the role of the city attorney, my understanding of the role of a city attorney is to advise the city in relation to its legal responsibilities pursuant to the ordinance. It's sometimes if you ask us a question, you're not going to like the answer because we're going to tell you our interpretation of the ordinance, which is in this case the law.
Right, so the relationship, you guys know how to counsel a city, we know the law. We'll tell you the law and you make your decisions from there. That's how it works. We work for you at that point. So we can tell you our opinions and then you're ultimately the ones that make the decisions.
But adding to that is, as the client, it's ultimately your decision. I mean, we can advise you however we want, and we're not shy to do so. But if what you decide is what you decide, and that's what we're bound to as well. But if you're doing something that we think is going to expose you to liability, we're going to get pretty loud and let you know that.
Sure. This is another two-parter. Please state how many criminal and/or civil jury trials each member of your proposed team has tried to a verdict. And then for each such trial, please give us the name, court, and case number. Then the second part of that. Okay, that's it. Okay.
That's all you know.
All right.
All right.
This one's going to be all Colin. He's the
I see you
litigator.
totting up some cases.
Yeah, no. Let's see. I was. Do you want in my capacity as an attorney or ones that I've co-chaired in?
Lead attorney.
As an attorney, okay. Because there was, as a law clerk, I sat as a
Lead attorney.
as lead attorney. Yep. Let's see. There was Mize versus Michigan Department of State Police that I tried not once but twice. We tried it. We didn't like the outcome. We appealed it. We got a reversal. We came back and tried it a second time and then won. Then they appealed, and then we defended it on appeal. Let's see, I've also tried, there was a case, Gary Satterfield versus, it was an ex of his, that ended up settling mid-trial, but that is one that I tried. Handful of minor ones at the district court level. Yeah, so there was two federal that I was lead on, and then a handful at the district court. I apologize. And all of my trial experience is civil. I've not tried a criminal trial.
I've done litigation, but all of my matters have settled before jury trial.
Same.
And let me clarify is that I think trial experience. Most cases, the way our system is set up, are designed to push you towards settlement. So most of my cases which are considerable, I've done in end up resolving in mediation or some form of settlement before that. It's good for everybody because it gives you a certainty of outcome, and it gives it lets you limit your risk, because a jury could give the plaintiff $1, they could give him $1 million, whereas the only time you really have control is in mediation. So the vast majority of my cases end up resolving prior to an actual jury trial.
So that question can roll right into number 6. Is that
Mine next.
Oh.
Please state which members of your proposed team have presented oral argument before the Michigan Court of Appeals, and on how many occasions?
Yeah, and let's see. I've argued in front of the Court of Appeals, at least 5 or 6 times. I'd have to go through my records to give you an exact list. Yeah.
Anybody else?
I have not.
Have not. Nope.
Thank you.
Ashley and I mostly handle transactional work, so we don't go to court a whole lot.
I guess I'll just round rather than next week for number 7. And I think we're done with that one, right?
Yep.
Okay.
Yeah.
So this is, again, variations on theme. Please state which members of your proposed team have presented oral argument before the Michigan Supreme Court and on how many occasions.
And I've never argued before the Supreme Court. Yep.
Short and sweet. All right.
to number 8? A developer has approached City Council regarding 4-acre city-owned property on the northern tier. They would like to redevelop into a senior care facility. The property recently became the city's as a part of a gift to the city. It is not currently listed for sale. The former use of the property indicates that there may be some environmental contamination on the site. The developer has stated that they would need to utilize brownfield tax increment financing to address any site contamination that may exist. What factors would you recommend the council consider in response to this request?
I guess I didn't hear a lot of that, but
It's hard to hear, yes.
Yeah,
Sorry.
that sucks, but basically, I'll paraphrase.
All right.
Sure.
A 4-acre parcel in the northern tier. Developers looking to redevelop a piece that's owned by the city. There's a need for brownfield cleanup on that. And and basically how would you handle that utilization of the brownfield tax increment in this situation?
Do you have any response to that?
So this is a question that we would have to research, but also I would need to research the brownfield tax increment financing, which I've done some financial work with reviewing mortgages and things like that, and the certain types of, primarily the financing that I've advised on is in relation to like small business administration loans. So that's something that we would have to research, but it's definitely something that we could find the answer to. And then regarding the contamination, I believe that the contamination would need to be addressed prior to the financing being approved. So I have assisted clients with walking through that process. Again, it's mostly in the private sector, though, in resident or commercial real estate. So it's likely very similar, I would think, but that would be something that we would have to research and get back, and the factors would likely be in something that we could easily find.
And, your important factors you have listed here, a big thing would be you'd have to get the voters on board with whatever you needed to do with it. So that'd be a campaigning issue that we'd have to address.
Well, if the city already owns the property, possibly. Is it zone? And then it's also you'd have to look at if it's zoned properly for the intended use as well, based on the ordinance and where it's at as well. So there may need to be rezoning done at that point if it's not zoned properly for the use that would be intended. Oh, it's got the answer on here. I didn't notice it, if you could tell.
Number 9.
Could do number 9. The council and neighborhood leaders are quite upset regarding a property in the Pinecrest neighborhood that is unkept. The grass is several feet high. There are strange smells wafting from piles of materials clearly visible on the property, and there are unpermitted structures on the premises. Previous attempts over the years to bring enforcement action have resulted in a protracted legal dispute that resulted in an unfavorable outcome for the city, yet issues persist. What advice would you give to the council? And the important factors are, well, do I read that?
I don't think we're supposed to have this.
Okay.
I didn't notice it for the first one, and we didn't look at it for the.
That's our
Right.
checklist.
Okay. Thanks. Right.
So,
The first piece is I need some clarification on what you mean by unfavorable outcomes from previous enforcement attempts. Because if you've tried this and they've, brought, federal claims to try to, prevent you from enforcing this action and it's resulted in an unfavorable outcome to you, there might be a judgment that might prevent you from doing anything else that's going to prevent further actions. We have a concept called res judicata, where when a dispute's been decided once before involving the same parties, you can't raise the same issues in a suit. So first thing I'd be looking at is what exactly were these previous outcomes before I could really give a firm opinion on that. With respect to the zoning issues, after figuring out where things stand legally after these previous decisions from the court and these unfavorable outcomes, what enforcement actions are left at that point with what's been decided, so I'm not wasting your time, with something that's going to get knocked out immediately with a res judicata motion. Anybody else have anything to add?
Sure.
I want to read it, but I also don't want to cheat, so.
Right. Yeah, flip it over so 10's not on the top here.
You'll notice if you just read it.
Yeah.
In 2005, A building alteration was approved by the Building, Zoning, and Historic Preservation Divisions, and work was completed to renovate a 2-unit duplex near downtown. The work completed in 2005 included modifications, including removal of the separation of units, a kitchen, living area, and added bedrooms. These changes effectively made it a 1-unit rental property. During a routine inspection, a housing inspector noticed that the rental license currently on file with the city is still a Class 3 rental license for 2 units, with each unit being licensed for up to 2. He alerted the housing administrator, who has brought the issue to your attention. There are currently 5 renters living in the building. What actions, if any, do you recommend?
Depends what the ordinance says. I'd have to look at that for one, but I'd have to really sit down and think about what that would look like, because if it was a mistake on the part, they've been living there for a while, so this is a thing where you'd have to consult the ordinance and make sure that you're applying it consistently, but if there was an oversight, we would have to come to an agreement in the firm of how to advise how to best remedy that. So that, I honestly, given those facts, don't feel comfortable saying what you would do, but it would depend on the ordinance and what it says, and we'd have to just enforce it in that way. Anything else to add?
I think you get to read Mr.
Okay. By city charter, all contracts must be approved by the city attorney. This is a frequent requirement. Please tell who will be involved in the review and how it will be billed.
So we would all potentially be involved, depending on the complexity of the contract. But reviewing contract is something I do daily, so I would be the lead on that. And then if I felt I needed a second or third opinion, I would get the others involved. We also have, not here with us tonight, we've got 2 other contractors, Ralph Carmichael, who is he's a professor at Michigan State, but he's good with mergers and acquisitions and large-scale business transactions like that. And then Thomas Oriot, who works remote for us out of the Detroit area, who is an expert in tax issues that could help with those issues as well. But as far as the contract review goes, like I said, I would be the lead on that, and that's something I do regularly.
He wants to know how it's billed too.
Thank you.
How would it be billed?
Oh, how it's billed, I didn't hear that part. Contract review is generally just billed hourly, depending on, if it's something that we would need to be looking at monthly or quarterly, then, we could come up with a flat rate for that, this much for these types of contracts, but generally it'd be hourly.
What is your experience in the property tax appeals on behalf of the municipality?
So I've done a few property tax appeals, a few out of Mason, which was a nonprofit. And so, I think we're pretty comfortable with those. Like I mentioned just a second ago, we have Tom Oriet, who's a tax expert. He actually worked for the Department of Treasury, Michigan Department of Treasury, for a number of years before he came on with us.
I have also done 2 appeals. I've only done one that was in the tax tribunal, but it was a couple years ago. But Tom would be I'm sure he's done some.
Yeah.
I mentioned that
He's
Do you handle any major trials in front of the tribunal? So which one?
in front of the tax tribunal.
I would assume so, just because all of them.
That's what I was
Yeah.
wondering, if it's
Yeah.
leaked from that last question. The simple answer is no. I've done a few hearings over the phone. Most of them were preliminary. And I was in Mason doing one, I believe, and this was 4 or 5 years ago. I'm also licensed in the U.S. tax court, if that matters. And I've done a few hearings for federal taxes.
Did you all submit for prosecution too?
Not specifically. I know in part of the bid it said that you might separate those. If that was something that you wanted us to handle as well, that would be Colin's jurisdiction.
Yep.
So I'll ask the questions.
We got 15 minutes left.
Okay.
So let's run through.
Sure. And I just wanted to point out that people who only apply for prosecution are going to have the full 45 minutes to answer.
Well,
just-
hopefully we'll wrap up.
What we'll do we'll use those for some breaks, actually. I should run shorter, so we'll use those as built-in breaks.
We'll see what time it is. So the first question for prosecution, describe your experience with district court practice. Please include trial court experience and number of cases taken to trial. Also describe any experience with prosecuting cases in other jurisdictions.
Yep. Oh, other jurisdictions. I do have experience prosecuting cases in district court. I've done. I've only had one go to trial. They tend to settle before that, but I have experience in district court. Other jurisdictions outside of Michigan or other jurisdictions within the state.
Both.
Both. Okay. I've done Jackson District Court. I've done been in the Detroit District Courts a couple of times, and the local ones around here. I've also had out of jurisdictions practice. I've second shared in trials in Pennsylvania federal court a couple of times as a paralegal. I wasn't yet licensed at that point, and I've had pro hoc vice admissions and other courts. California, right? Colorado. Thank you.
Yeah.
Been doing this for 10 years, so it's tough to give you a comprehensive list as I sit here, but I do have experience in those things.
I've got some really obscure district court experience from previous employment. I did an action for replevin in a district court. I've done a couple other, like landlord-tenant type things. I've done a lot of that stuff in the district court. It's primarily in Genesee and Livingston County.
And I've done a few landlord-tenant here in Ingham County. And then all of us, I believe, are licensed federally in the Western District.
Correct.
And Colin is in the Eastern District as well.
Yep, and the Sixth Circuit and the Supreme Court.
And I'm also licensed in the state
U.S.
of
Supreme Court.
Pennsylvania, if that matters, but it doesn't really.
Got a big practice in Pennsylvania?
No.
Just
Okay.
wondering.
Big client. in
One very
Couple
large
of-
client,
sorry,
yeah.
A couple of corporate clients.
Okay. How does your experience as criminal defense attorney benefit you if selected to be the city's prosecuting attorney?
I don't think any of us have any experience
don't.
as criminal defense attorneys, so the answer would be that would be the answer.
Yeah.
The cases you handled in district court?
Civil.
Oh, civil.
Yep,
They're all civil.
exactly.
Okay, great,
Yep.
thank you.
This question is not quite worded correctly, but as opposed to me, who has actually had to go through this process, what is your experience with alternatives to jail for your clients? The question doesn't say for your clients. Or just,
Right.
to make it clear, I've had to make those choices for myself. And in other words, talking about special status designations, deferred sentencing, treatment courts, and within that context, provide examples of cases you or your firm have handled that fall under each category. And I kind of take it from your answers, you
Yeah.
haven't done any criminal stuff, so
Correct.
the reality is none of that applies here.
Correct.
Right.
Correct.
Thank you.
Colin's defended a couple of criminal issues civilly, but not in
We're
criminal.
talking criminal court.
Right.
Yeah.
Thank you.
Considering jail reform legislation, what support mechanisms would you consider in a plea agreement to allow for successful completion of court judgment?
In a plea agreement, it would be case specific at that point. I would anticipate, is is the crime based on substance abuse? Do we want to put them into some sort of a form of drug court or something, some alternative method like that? Requirements of maintaining employment, requirements of maintaining drug testing, all those things to make sure that they're able to keep up with the terms of it, things of that nature.
Please explain what factors you consider when offering a plea agreement. Part A of that is how would you balance the need to deter future violations and someone's inability to make these qualified laws?
Sure. Well, and I think that hits the asking factors to be considered in a plea agreement. I think that is what you look at is number one, deterring future violence. You're looking at, do they have a hit? What does their criminal history look for? Are there any mitigating factors to the particular crime they've committed?
The nature of the crime in and of itself.
Right, the nature of the crime in and of itself, absolutely. And with respect to, deterring future, you want something of the nature where they have. This would be similar to what you have in settlement agreements, where you have an enforcement mechanism that steps in when somebody breaches it, such as a deferred sentencing. If they don't keep up with the terms of their probation or their parole agreement, they have a custodial sentence waiting for them. Things of that nature.
Let's ask whatever the extra additional questions were. I think we
Yes.
want to ask those in the last little bit.
Okay, actually, I'll pass on my follow-up.
Okay.
Thank you.
Well, and now read number 19.
Number 19.
That's the last one. Yeah, that's what I was saying.
Oh.
We can fit it all in right here.
How can you ensure that the primary or assistant prosecutors will adhere the charging and plea bargain policies established by this council?
By reviewing the plea agreements that they're entering and making sure they match up to the policies that you set forward.
Anyone have any additional questions? And if not, we'll allow you guys closing arguments, so to speak.
All right.
Brief closing.
Sure.
Brief. We'll be brief.
I do have a final question. So I work in public health during the day, and we've seen a lot of changes with the type of trainings that groups are going through, including law firms. And so any implicit bias trainings that you all have participated in?
I was involved in an implicit bias training. I was one of my law school classes was mediation training, and we did implicit bias training at that point. So I feel that sort of training is very important and very useful and very necessary, because you're right, implicit biases, they hide in all of us, and it drives. What I find from my civil rights work is that we're not well set up to prosecute people who are victims of implicit biases. It assumes that there's some intentional intent behind the discrimination, if people. And it often comes down to a proof of of intent to discriminate, and if it's hiding implicit, it's really not well set up to have that. So you have people that encounter these situations, and they come to you and they just know that something is wrong happened to them, but they can't point to anything specific to show that it was because of the protected status, even though they know they're being treated differently. I mean, we have the concept of disparate treatment, but that you have to prove it with statistical evidence, and it can be tough to get a court to take that sort of a claim seriously because of that. And so, the short thing is I think that attacking implicit biases on a systemic level is very important and very, a very excellent idea.
I haven't had formal implicit bias training, like with a full course, but I've had some with the community organizations that I've done. So it's just like a course here or there, a lecture here and there. And that's part of what I mentioned earlier in the interview that we're looking to hopefully set up in the future for that organization. But I agree with the things he said about how important it is.
Was it right, Casey?
No, I mean, I don't have much to say. Like I said, we're all local. We'd love the opportunity to serve the community. We're all Spartans, in one way or another. She's technically from Wisconsin, but we forget that.
Lived here for over a decade, man.
But yeah, I mean, if you have any follow-up questions or anything, you know how to get a hold of me, and just let us know. We appreciate the time.
Thank you so much.
Thank you very
Thanks
much.
for coming in.
You want these back?
Yeah. I should give it to you. Thanks for coming. Thanks for coming. Thanks for coming.
Do we want to take a break, or do we want to?
We'll go over the template after this.
I don't need one.
Can we go over this for whatever extra thing?
I think I will need to break down to the next one.
That's it. It's close.
So, I was asking, for the people that are solely applying for prosecution, they so then it ends up being, if time is over for someone that's applying for all of them.
We have a hard stop at 45 minutes. I think it's kind of.
Just trying not to
Yeah,
let it be all
yeah.
for
Good.
Yes, I think so. So I think we should probably ask up front if they are applying. for
You ready? Yep.
prosecution,
Miller Johnson.
so that we-
Are you Miller from Miller Johnson?
Yeah.
Okay, perfect.
That was a mess.
Well, that's all right. I mean, practice.
Guess I'll sit in the middle.
Hopefully this time
You
we
can spread out.
I can spread out, yeah, I'm by myself, so. I didn't, we're a big firm, so I didn't really designate a lot of our,
We failed to clarify last time. Are you applying for both roles, both city attorney and prosecutorial piece?
yeah, yep, yep.
Great.
That's,
And would you mind introducing yourself?
yes, so my name is Richard Cherry. I am a partner at Miller Johnson. New to Miller Johnson, my background is primarily in 16 years of working. Can you hear me?
Yep.
Okay, 16 years of working in the public sector. Initially, I went to Chicago, was a Cook County State's attorney for, I want to say, 6 years. Approximately 6 years, most between 5 and 6. So, the majority of it was doing trial work, DUIs, misdemeanor work, felony prelims. Then I moved over to the civil division, where I practiced about a little less than a year. Had a kid, and we're from Michigan. My wife and I kind of freaked out and decided to move back to Kalamazoo. And so I got a job at the city attorney's office, where I began my career as a municipal city attorney for 8 years, primarily as assistant city attorney, and then I got promoted to deputy city attorney. So
Was that for the city? Yeah.
for the city of Kalamazoo, yes. And when I was at the Cook County, I did, as in the civil division, I did tort litigation, tort defense litigation, 1983 litigation. Want me to explain what that is? I can. So defending municipality against civil rights violations brought on by plaintiffs. Under statute 1983. As a city attorney, I was initially brought on for litigation, but I guess my boss saw something in me, and so he kind of took me under his wing, and kind of groomed me for the city attorney's office. I'm sure you're going to ask me why I left to go to private practice, and I'm sure you can ask me that question. But, what's that?
It's not.
Not on your list, but you can ask me. But while I was a city attorney, I did everything from Brownfield. I was a Brownfield counsel for city attorney's office, EDC, assistant FOIA coordinator, tax appeals, HR liaison, public safety liaison. Then we also did ordinance prosecution and ordinance drafting, general counseling, and when my boss was gone, I acted as the city attorney, being the deputy. So that would be. I also was the legal advisor for the Brownfield board, so I'm well versed in Open Meetings Act, and also pinch hit for him when he was not available for the city commission in Kalamazoo. I can go on. I don't want to just throw up.
These are going to come up again, so we'll save.
We've read your submissions.
Okay, good.
Save your ammo.
All right.
Firm-based, who would serve as lead attorney? What would be your response time and availability?
Okay, so I'm going to be the lead attorney. I have the most experience as far as the city attorneys concerned in our firm. My response time as far as emails, phone calls, is right away. We pride ourselves in responding to our clients right away. There are times where I'll be in court or a hearing or something like that where I can't respond right away, but I will do as soon as possible. As far as drive time, it took me an hour and 20 minutes, hour and 15 minutes to get here. We understand the distance, so I intention to be here for council meetings every first and third. I believe that's right. First and third Tuesdays for your regular business meetings, and any special meetings that you may have. Either if I can't do it, if I'm either on vacation, or we have lead attorneys that will be here for your city commission meetings or city council meetings. Sorry, and if I do that from time to time, just forgive me.
Diversity, equity, and inclusion are not just words in the city. What racial justice work has your firm been involved in, and how does diversity show in your firm, and how does inclusion matter?
So, to me, obviously, I'm an African-American male. Diversity is very important to me. Inclusion is very important to me. I wouldn't have chosen a firm if they didn't take that seriously. And when I say chosen, I actually called up someone from Miller Johnson and asked if I could come over. And they hired me. So one of the things I know about Miller Johnson is, and they have things called a program called Project Give Back, where the firm spends $1 million of free legal services to indigent individuals in the YMCA for litigation. In addition to, on the corporate side, what we do is also provide legal services for new upcoming businesses as well. So in addition to that, we have what we call the program called Actions for Change. And internally, what we're trying to do is make sure that our attorneys are well-versed in implicit biases, well-versed on diversity and inclusion, and we require our equity members to, in part of their evaluations, to state what they have done to not only promote diversity within the firm, also promoting diversity in the community at large, in Grand Rapids, Kalamazoo, and Detroit. So. We also have, I don't know, and we do have, other than myself, other members, other attorneys of color that serve work at Miller Johnson.
As city attorney, you must have a good understanding of the city charter and city ordinances. So, Part A, Subpart A, perhaps. Do you believe that it is important to enforce the city charter and ordinances even when enforcement may be contrary to an outcome desired by the city council or city staff? Part B, using the city charter as your guide, what is the nature of the relationship between the city charter, city council and city attorney? And the nature of the relationship between the city council and city manager?
Okay. So, one thing that city charter is law. Your ordinance are law. So, my job as an attorney is to help you follow the law, right? And advise you in the following of the law. There were times when I was assistant or deputy where we had to tell the city commission, no, we don't advise that. We don't think that's in accordance to the ordinance. We don't think that's in accordance to city charter. Again, that's our job. You might not like our answer, but that is our job as city attorney to advise you to make sure that you're making decisions based in law and making the right decisions. We, as a city attorney, although we do answer to, and this will go to the next question, right? We do answer to the city council. We represent the municipal corporation, right? And so the city at large. So, and the citizens of the city. So, we don't represent one, no offense, one particular council person or body. As far as B, what does the city charter say about the relationship between the council and the city manager? I'm going to use an analogy. City manager is like the coach, and the city commission or city council is like the GM, right? So, city manager is responsible for the operations of the organization, making sure it's running smoothly, and advising the city council on some of the policy, implementing their policies, implementing the charter, and implementing the ordinances. The city attorney's job is to counsel, a legal counsel to the city council. That means giving good, solid, sound legal advice. And there is an interaction between, I know, the city council or city attorney and city manager. They work in concert, hopefully, to provide the best type of service to the city council.
Please state how many criminal and or civil jury trials each member of your proposed team has tried to a verdict, and for each such trial, please give us the case name, court, case number.
Okay, so when I saw this question, jury trials for me personally that I first chaired criminal jury trials, I want to say 7. Total 12. As a civil jury trial, first chair 1. Oh, that was only chair because I didn't have a second chair. So only chair as a federal lawsuit. So for the team, and this is where I'm going to get into having a full service law firm. If I'm not cutting it as your litigator, we have experienced litigators on our team that have tried numerous jury trials. We have on our team, I might have the most trial experience because of being in public service, but we do have a host of attorneys, other attorneys in our firm, who can come in and try a case for the city of East Lansing.
Thank you.
If it's okay with everybody, I'll just combine sort of the same question. This is Appeals, and then question 7 is before the Michigan Supreme Court.
Okay.
I do realize it kind of piggybacks.
Yeah. Do you still want my case numbers? I did write down my case numbers.
You can get us the.
Okay. I had to look through my trial book because I actually kept a trial book with all my case numbers. Okay. Okay. All right. I have case numbers if you want
Submit
them.
it to us later.
Okay, I will do. And a lot of them are out in Illinois, my trials. As far as Michigan Court of Appeal cases, I have argued 3 times in Michigan Court of Appeals. My Keith Eastland, one of the members of my team, has argued, he said, once in the Court of Appeals, but he prefaced 5 times in the Sixth Circuit. So I have argued once in the Sixth Circuit. And Pete Peterson has argued, I believe he said 2 times in the Court of Appeals. None of us on our team have argued in front of the Michigan Supreme Court. However, again, Miller Johnson, we have attorneys that are skilled and trained and experts at arguing in front of the Michigan Supreme Court. And so, again, if we need to have an individual come to argue in front of the Supreme Court and has experience, we will have that for you.
This is kind of one of the long ones.
Okay.
The developer has approached the council regarding a 4-acre city-owned property in the northern tier. They would like to redevelop into a senior care facility. The property recently became the city's as part of a gift to the city. It's not currently listed for sale. Former use of the property indicates that there may be some environmental contamination on the site. The developer has stated that he would need to utilize brownfield tax exempt increment financing to address any site contamination that may exist. What factors would you recommend the council consider in response to this request?
Okay. So, like I said, I'm finishing up work with Kalamazoo and the Brownfield. I'm still technically Brownfield attorney for them, kind of. So, the first thing I would say, if it's a gift and you accepted it, one of the first things you probably want to do on the property is do a per statute, a environmental assessment on the property, at least a phase 1. And then after you do that, you can, I believe, market it for sale. You said there's a someone who's going to redevelop
Senior care facility.
senior care. Well, then you have to see if it's zoned properly. If it's zoned properly, then you're fine. But if it's not, then you have to get it rezoned, of course, if that's what you want. And then it has to fit into your master plan for future zoning. So those are some of the considerations. You also want to consider the neighborhood that it's in, if it's in a neighborhood. A lot of times with City of Kalamazoo, what we used to do is once we had an idea of what we wanted to do with the property, if there's a developer that came in, we would have public outreach in the neighborhoods, it kind of got harder with COVID, but we have Zoom meetings for folks in the neighborhood that are affected to have a voice that see if that would be a use that they would want in their neighborhood. Those are the initial considerations I would tell you to look at.
The council and neighborhood leaders are quite upset regarding a property in the Pinecrest neighborhood that is unkept. The grass is 7 feet high, there are strange smells wafting from piles of materials clearly visible on the property, and there are unpermitted structures on the premises. Previous attempts over the years to bring enforcement action have resulted in a protracted legal dispute that resulted in an unfavorable outcome for the city. Yet issues persist. What advice would you give to the council?
Okay, so this is actually very similar to a case I had, multiple cases that I had. There were an issue, one case that I can remember where the individuals were ready to use burning tires in their backyard, which is, again, a permitted use for their property. And so we never, because it was enclosed, and so it was really hard for us to enforce it because we couldn't see over to, I could tell you what we actually did. We had an administrative search warrant to go in there because we had enough information to go into the property to see what we knew what was back there, but to get some evidence. We went to court. The court unfortunately gave the individual a slap on the wrist, and then in order to remedy the situation, we actually got a court order to abate the nuisance because the neighborhood was upset. What are you going to do about a city? And that's what we had to do. Unfortunately, it's a Band-Aid, right? Because if you go in there, clean it up, who's to say they're not going to do it again? It's a cost to the city to go in there and abate the nuisance. So it's although it might remedy the situation initially, it's unfortunately it won't solve it. So we did seek civil remedies on it. Under our nuisance statute, sued them, and luckily a judge, because we did criminal first, didn't work. We went civil and sought an injunction and got it, and then they violated it, of course, and then there was a civil penalty, held them in contempt. So that's similar to this. That's what I would recommend the city council to do at that point.
Another scenario, in 2005, a building alteration was approved by the Building, Zoning, and Historic Preservation Divisions, and work was completed to renovate a 2-unit duplex near downtown. The work completed in 2005 included modifications, including the removal of the separation of the units, a kitchen, living areas, and adding bedrooms. These changes effectively made it a 1-unit rental property. During a routine inspection, a housing inspector noticed that the rental license currently on file with the city is still a Class 3 rental license for 2 units, with each unit being licensed for up to 2. He alerted the housing administrator, who has brought the issue to your attention. There are currently 5 renters living in the building. What actions, if any, do you recommend?
So, first I would want to know some more information, like how many rooms are in the unit. If the owner if it's owner occupied, if those 5 renters are family, because all of those factors factor into what classification. And I looked at your renters ordinance and what classification it is. It's classified as as class 3. There's a possibility you can tell the building inspector that if they need to reclassify it, that they can seek an application to reclassify so they can go and gain compliance. But if all else fails, if it's non-conforming, if there are 5 renters on college students that Kalamazoo, that's what we have to deal with a lot, as you do too, Michigan State. And if that's the case, and it's not certified correctly, then one of the considerations you have, you don't want the kids or whoever's renting the house out on the street. You know, if you come down on the landlord or the owner, then where are those people going to go? Those are some of the real life considerations you have to make when you make those type of decisions. And so you just got to weigh a lot of that stuff. And you, as an attorney, you got to figure out exactly what you're dealing with before you give legal advice.
By city charter, all contracts must be approved by the city attorney. This is a frequent requirement. Please tell who will be involved in the review and how will it be billed.
So, I've been with Miller Johnson for 6-7 months. And so I have learned that delegation is key to keep costs down for your client. We have very capable paralegals that can review contracts, that can keep the cost low. We have associates that can review contracts and give me a synopsis of the contract, so I don't have to spend that much time, billable time, reviewing the contract as a city attorney. And so I think, especially if I'm going to come to this body and represent you on a contract that's up for approval, I'm going to want to know what the contract entails. And so I will review the contract, a synopsis of the contract, so I know what we're dealing with, so I can advise you appropriately. But at the same time, keep costs down for the initial review.
Thank you.
I wanted to ask for a time check.
It is 6:08, and I think we started around 5:50,
About 23 minutes, I started.
Sorry if I'm too long-winded.
You're fine. Very good.
I'm going to combine these 2 questions too, if that's all right. What is your experience handling property tax appeals on behalf of the municipality, and how have you handled any major trials in front of the party?
So I have, part of my duties as a assistant and deputy city attorney was to do tax appeals. And so I've gone through disclosures, everything up to trial. Normally, as a municipality, we don't normally go to trial because there's the high number that we have assessed. There's the low number that they have, that they want their taxes at, and then we meet in the middle. And I want to say 99%. I think we had one trial at the tribunal, and that was before I even got to the city. I want to say 99% of the trials were settled, or the cases were settled. But our firm, we do handle tax appeals, and not for municipalities, for clients. And so we do have 2 attorneys that have handled tax appeals in front of the tribunal that could aid me or as a city attorney in trying that in front of the tax tribunal. And I just want to preface that our team we have a team, but we're a big firm and we're all on this same team. So.
Great.
Will this be a different individual, or how do you guys, I'll ask that as well, how do you manage this prosecutorial piece?
So with my prosecutorial experience, especially in district court, I think I would be the lead. Well, I know I will be the lead. And we have 2 associates right now who do prosecutorial work for in district court for the city of Muskegon Heights. So they have experience in district court. So they would probably be doing the majority of the pre-trials, settlement conferences, and lower level trials, bench trials. If need be, I can do the jury trials if it's that complex, or at least sit for a chair.
I'll roll that right into the question.
Okay.
Describe your experience with district court practice. Please include trial court experience, number of cases taken to trial. Also describe your experience with prosecuting cases in other jurisdictions.
Okay. So I'll start with my experience in Illinois. I can't even tell you how many bench trials I've done, because hundreds. I don't know. We would try cases. We were a machine. And there were 2 attorneys, first, second chair, and sometimes the third chair in our rooms. So anywhere from license suspenders for misdemeanor. I'm just dealing with misdemeanors, for misdemeanor trials to DUIs, OWIs, call it DUIs in Illinois. In city of Kalamazoo, I was, as deputy assistant city attorney, I practiced in district court a lot. I had 1 jury trial in district court where I first only chaired. For the most part, we were able to reach a settlement on the majority of our cases. Either they be delayed sentences, they be some type of community service, little fines. So, very experienced in district court myself. So, I don't know if I answered your full question.
You did.
Okay.
Next question. How does your experience as a criminal defense attorney benefit you if selected to be the city's prosecuting attorney?
So I have honestly never been a criminal defense attorney. I've only been a prosecutor. So, but I did talk to our team and asked who had criminal defense work. Rich Perez, who is on our prosecution team, he does criminal defense work for Miller Johnson, and he basically imparted that it helps him with plea offers. It helps him see both sides of the equation of the case. So it makes him a more sound litigator when it comes to finding a resolution or going to trial.
After Mr. Brookover wisely changed this question, I'm also going to tweak it a bit.
Okay.
What is your experience with alternatives to jail for clients? For instance, special status designations, deferred sentencing, treatment courts. And then, the subpart, can you provide examples of cases you or your firm have handled that fall into those categories?
So I can't really speak to the firms. I can speak to my experience as being a prosecutor in district court, and what so special status, I'm guessing veterans courts and that. So we had a veterans court. We had a mental health recovery court where I sat in on, that I prosecuted for the city. Also, OWI court, we had those, and my experience in those, I was the OWI prosecutor for the city. The point is to get that person well. The point is to make sure that person is not to prosecute them. So That's the point of the specialty courts. It's not to have a misdemeanor hanging or a felony hanging around their necks, but it's just to make sure that they can get well and get out of the system. So that's the point.
Considering jail reform legislation, what support mechanisms would you consider in a plea agreement to allow for successful completion of a court's judgment?
So if they have in those specialty courts that I just mentioned, OWI court, or a drug court, or I don't know if youth diversion courts, if you see someone that you think is eligible for those courts, you make sure you put that in your plea agreement. Because a lot of times in district court, I know that there are public defenders now, but back when I started, there weren't. Which, coming from Illinois, I was just like, oh, really? That's crazy. But for me, I to ensure that, because one thing I learned being a prosecutor, your job is not just to get the conviction. Your job is to seek justice. And what's justice for a individual is to ensure that their rights are protected as well, no matter if they're the defendant or not. So as far as plea agreements are concerned, I also will do like diversions. They don't have marijuana diversions anymore, but 7411 we used to do that. A lot. For MIPs, we used to. I know that the ordinance or statute has changed quite a bit. So the first one I believe is a civil infraction, and then it ratchets up from there. And especially in a college town, you don't want a young person to be saddled with a misdemeanor because it comes back to haunt them. So, especially if they're applying for law school, anything in education, anything in medical field, the diversions and delay sentences is how I would handle it to help ensure. Yep, sorry.
Please explain what factors you would consider when offering a plea agreement, and how would you balance the need to deter to violations and someone's inability to pay fines and costs?
So the factors that I use are age, because I think their chances of rehabilitation. Normally, young people do stupid stuff, and so you take that into account. I know I did record, see the criminal record, see how many convictions they've had, seriousness of the violation, if there's a victim involved, because the worst thing you could do is plea out a DUI when someone was injured, and not take into account what the victim in that plea. And then the offense, what type of offense it was, if it was like a DUI or some type of aggravated crime of violence, then you take that into account. And then the indigency, are they poor? Can they pay a fine? You know, do you want to give them, recommend no fines, recommend community service to deter, instead of like jail, deter them with community service. It's like a lot of community service. If you do this, you might have to do a lot more community service. So those are the things that I look at when I prosecute.
Last question. How can you ensure that primary or assistant prosecutor would adhere to charge or plea bargaining policies established as accountability?
So, and we had that in the city of Kalamazoo as well. The city commission gave us a charge that they wanted to do, first decriminalize the ordinances. We did that to some extent. I think it's still the process since I've been going. It's still going on. One of the other things I would do is ensure that we know the policy, everyone follows the policy, make sure I monitor that they're doing the policy correctly, because at the end of the day, I'm the city attorney, so it, buck stops here, to use that blunt, or that analogy. Cliche, sorry. But it is what, again, I intend to monitor or be accountable to you all, and accountable to also the people of the city of East Lansing. So,
Just a clarifying question. Did you mention 2 other attorneys for prosecution? There
yes.
was Perez, and who was the other person?
Elise Hildreth.
And are those folks' bios in here?
I believe so. They're in the addendum. Yes.
Okay, thanks.
And both people of color, if you want to know.
Thank you.
So, yeah.
I had a couple of questions.
Sure.
So I appreciate that you kind of outlined a little fee schedule here, but then also you mentioned that you are subject to other payment structures, including flat fees and monthly retainers and all of that sort of stuff. So our previous city attorneys are through their account system to ensure that that we didn't have open tabs, so to speak.
Yeah.
So I was wondering if you would be amenable to monthly or yearly cap structure. And then also, I appreciate you splitting out the defense or the prosecution services on the addendum. Would you be, if we did end up retaining somebody else as the defense or the prosecution portions, or my dad was a defender, so I just like default to that. But,
Yeah.
the prosecution person would still be interested in taking on the primary role of the attorney.
Yes.
Okay,
Yes.
great.
And as far as to answer your question, we do all kinds of arrangements. And so if we are offered or granted the position, we will work with you to try to get the right fee structure that works for you. So if that means cap yearly, and we will tell you when we're coming close to that, I'm sure you but yeah, we will work with you.
Well, I appreciate that.
Yeah, thank you, sir.
Oh, thank you.
Thank you.
Thank you.
Who's on? Who's on?
Thank you. Thank you.
So did you
Yeah.
All right. We're good to go.
Yeah.
Welcome. Thank you. Appreciate it.
Well, obviously, we've received your answer to we've received your proposal, which is great. Could I just clarify, are you applying for the full city attorney plus prosecution services, or just municipal for the contract?
The whole thing.
Whole thing.
But we'll take whatever we can get.
All right.
We're not going to be picky, obviously.
All right, well, why don't you kick off and give us your background and experience that you bring to this role if we are select you.
Absolutely. So again, I'm John Clark with the law firm of G. Markle, Mullins & Horton. I have been in the municipal business for going on 27 years, representing in some form or fashion close to 20 municipalities, nonprofits, district courts. Been with the firm since 1995. I'm a senior partner, member of the board of directors, and I run our municipal group, which is 8 lawyers. Unfortunately, 2 of my main guys, Steve Hitchcock, who's been in the business for 40 years, who handles the tribunal work, the the real estate issues, contamination. He's actually out of town. And my other partner, Tony Chubb, who does a lot of municipal, is actually at the City of Pontiac right now, handling the situation there. But our experience is very broad. We handle every facet of municipal business that's required, from the ordinances to prosecution work, handling council meetings, FOIA issues, open meetings issues. The gamut is there. I think our resume speaks for itself. We have a Lansing office that Travis, I'll give him a chance to introduce himself, operates, and then also we have an office in Troy. In terms of myself as a lead guy, yesterday I was in Saginaw. Today I was in City Wayne and City of Taylor and Bradford Township, and next week I'm going up to Alpena. So my office is wherever my car is and wherever my clients need to be. So with that, I'm going to have Travis introduce himself briefly, and then Carrie.
Good evening, Travis Comstock with the firm. I came on in May. I have almost 10 years experience previously with the Department of Attorney General, where I was lead counsel for two of the departments there, Department of Health and Human Services and Department of Education. Broad experience in administrative matters before ALJs and other types of situations, appellate courts and federal courts at all levels. And we do have our office here in Lansing that's near the Ingham County Circuit Court right across the street. So happy to have folks over and take a tour there if we need meetings. We have a local location where we can have those occur.
Was it a dissatisfied client that you got?
No, trying to defend my fatherhood on a rope swing and fractured my knuckle.
Well, it was a well-won.
And Carrie Miller.
Hi, my name is Carrie Miller, and I have been prosecuting cases since 2006. From 2004 till 2006, I clerked for a circuit court judge, so I kind of learned about trials from the inside out, and then started at the Oakland County Prosecutor's Office, and I was there from 2006 until 2018. So while I was there, I was in many different divisions. I wrote warrants, I tried circuit court cases, district court cases, child abuse, drug cases, forfeiture cases. So took many cases to jury trial, bench trial, and then I joined GMH in 2018. And since I've been with them, I've done all district court prosecutions for them. So prosecuting local ordinances and then building department cases, things like that. So my entire career has been working in the prosecution side of criminal law.
Who would serve as lead attorney? And what would be your response time and availability?
So myself and Tony Chubb, who again is in Pontiac, will be the two main people. Our response time is second to none. I pride myself on response, whether it's with an answer or I will get back to you with an answer in a specified period of time. I have to tell this quick story. So I had a client of mine who loved to write press releases as a city manager for a place up north. He sent me a press release at 8 o'clock in the morning, and I was in court, and I read it as I was sitting waiting for my case to be called. And I looked at it, I said, there's some issues with this, So I got out of court at 10 o'clock, and I called him, and I said, hey, I got some issues. He said, well, I didn't hear from you in the last 2 hours, so I just sent it out. So literally, I think that's my reputation in terms of timeliness. My availability is to service the needs of the client. So if the client has needs, then myself and my team will make ourselves available depending on the circumstance. Some situations, some clients, things are very active, some are quiet, and it always seems to flip around depending on the circumstance. And certainly COVID has been a challenge. So obviously, and I'm seeing more and more in person. For the last year and a half, things were all virtual. But in terms of availability and responsive time, that's something I think we pride ourselves on, and why I think we've been so successful.
Diversity, equity and inclusion are not just words in the city. What racial justice work has your firm been involved in, and how does diversity show in your firm, and how does inclusion matter?
So in terms of diversity in our firm, we have 2 women who currently serve on our board of directors. We have 2 members of the LGBTQ community. We have 2 members of our firm who are African American. Inclusion is extremely important. I'm public sector. This is what I do. I think it's a very important part of my practice, of my group's practice. Something that we strive to do. It's something that we encourage our clients to do. And in that regard, we have written certain ordinances, inclusion ordinances, for some of our communities, including Highland Park and Saginaw. Something that we're extremely proud of, and I think it fits in with the racial justice area, is that under ARPA, the city of Pontiac originally was only granted about $3 million. And in working with some of the local politicians, state senators, working with the governor's office to indicate that we thought that that amount of money was unfair. Pontiac is a mainly a minority community. And through our literal negotiation, we were able to grow that to over $36 million. That is money that goes directly back to the people of the city of Pontiac. And I certainly that would encourage, and I think will result in racial justice for that community in all kinds of ways. Through provided services, through better roads and streets, through funding things like rec centers, senior centers, important things that help the community.
As city attorney, you must have a good understanding of the city charter and its ordinances. Do you believe that it is important to enforce the city charter and ordinances even when enforcement may be contrary to an outcome desired by the city council or city staff? And part B, using the city charter as a guide, what is the nature of the relationship between the city council and city attorney? And the nature of the relationship between the city council and city manager?
So the first question, it's not important, it's required. That's our job. We have to interpret and apply the charter, and that's regardless of the political whims or wishes of those on council, mayor, or city manager. Otherwise, if you thwart the charter, which is basically the gospel or the governing document of a community, then as a city attorney, you haven't done your job. And having been in the business as long as I have, I've come across this issue more times than I want to count, and it's a very difficult situation. It does take sometimes some mediation and some education regarding what my opinion is or what my interpretation is, but ultimately the charter has to be followed. And if council or mayor, if there's an issue with the charter, then either they can attempt to modify the charter through a resolution or through a charter commission. If there's an issue with the charter, then you got to fix the charter. On the second issue, and in several of our communities, there's a city manager form of government, including the city of Wayne. And Redford Township doesn't have a city manager, but they have a township superintendent, which is really the same thing, although it's under the Charter Township Act. And so there is a dichotomy when representing the city as a whole. What is the role of the city attorney vis-a-vis the city manager and council? Under, I believe, Section 7 of your charter kind of lays out each of the positions and the responsibilities. So in terms of the city council, city attorney, city council, based on my reading, appoints both the city manager and the city attorney, so they're the appointing authority. Many charters provide that the city manager makes the appointment subject to council approval. So my reading of your charter was that it's council that has that. The city attorney is the legal advisor to the city council in terms of their legislative role. The council can direct the city attorney to engage in litigation, I believe is one of the specified areas. In terms of the council and city manager role, again, it's the council that appoints the city manager. The city manager is responsible, and that's the word in the charter, responsible to the council. But council cannot interfere with the judgment, discretion, decisions of the city manager, nor can council interfere or go directly to subordinates of the city manager. And that's fairly typical language in charters, and it makes a lot of sense. You hire somebody, you hire a professional to run the day-to-day operation. This body, the council body, is the legislative. You set policy, you set the budget, you have the power of the purse. But ultimately, that the day-to-day operation, that's why you hire a good city manager, to make those decisions, to make those recommendations.
Please state how many criminal and or civil jury trials each member of your proposed team has tried to a verdict.
So, and I know you wanted case numbers and things.
I'm not worried about that.
Okay. I was going to say. So I've personally handled 5 civil trials, dating all the way back to my very first jury trial was up in Genesee County in 1996, and I got a directed verdict for McLaren Hospital, which I was ecstatic as a brand new lawyer. So 5 for me, and I prosecuted back in the day. These two do a lot of prosecution. I do more of the more municipal side. I also do a lot of labor employment, but I've had dozens and dozens of criminal trials. Carry up.
Yeah, I've tried probably close to 30 or 40 jury trials easily at the county. Since being with Gianmarco, I've tried an additional 5 jury trials in the last few years. They're less likely to go to jury in district court as they are in circuit court. As far as bench trials, which is a trial in front of just the judge.
Yeah, that's not the question.
Okay.
Yeah.
Just out of curiosity, is Judge Hassan still alive?
Yeah.
You talk to him?
Yeah, I talk to him all the
Tell him I
time.
said hello.
Oh, I will. Yeah, he did my wedding.
Well.
Yeah, he's actually on the
Go
bench
ahead.
right now. He's
I'm sorry.
visiting. Yeah.
And you, sir?
Having a limited role with this group, I mainly coming from the Department of Attorney General, and I clerked for state court and federal court prior to that. But Attorney General, we were mostly motion litigation, although I did some child abuse and neglect administrative proceedings where there were witnesses and things like that, and took those on appeal to the Court of Appeals. So
the answer is none.
None.
Thank you.
Lucky guy.
All right, back to me. I'm going to combine the next 2 questions.
Yep.
They're basically the same. Can you say which members of your proposed team presented oral argument before the Michigan Court of Appeals and also before the Michigan Supreme Court?
Yeah, so personally, I've had, but when you say Court of Appeals, I've had 6 Circuit Court of Appeals, federal court, and I've had 3 Michigan Court of Appeals cases. Mr. Hitchcock, and I talked to him on the phone, he's had 4 Court of Appeals, 5 Sixth Circuit, and Mr. Hitchcock has argued twice before the Michigan Supreme Court on retiree health care issues. We've had done a lot of work in the retiree health care world. In fact, I did some consulting for the city of Lansing about a year ago when that was a hot topic. I don't know if you remember all that, but I was involved with that situation. So that's so. Does that answer your question? Okay.
I've had 2 at the Court
Oh,
of Appeals.
okay. I'm sorry.
I've had 2 at the
Travis.
Court of Appeals, not yet at the Supreme Court.
Yep, it's a story problem. A developer has approached the council regarding a 4-acre city-owned property in the northern tier that they would like to redevelop into senior care facility. The property recently became the city's as a part of a gift to the city and is not currently listed for sale. The former use of the property indicates that there may be some environmental contamination on the site. The developer has stated that they would need to utilize brownfield tax increment financing to address any site contamination that may exist. What factors would you recommend the council consider in response to this request?
So, I guess number one, and again, I wish Mr. Hitchcock was here, but I will do my best to respond to this. It's an excellent question. First of all, you have to make sure that the intended use is permitted under the zoning, and if not, whether there would have to be some exception to the to the city zoning ordinance. Number 2, I think before you can entertain a brownfield tax increment, financing, you would have to know the value of the property. But before you're going to give a tax break, you have to know what the value of the property is, so that you know, in essence, what potential taxes you're not going to realize. And so, in order to do that, you have to seek an appraisal. Before you can do an appraisal, I think you'd have to do a phase 2 to know what the level of contamination is. And based on the level of contamination, then that would tell you what kind of remediation would be required. And then ultimately, an appraiser could tell you then at that point, if the property is clean, and because it's going to be a senior care facility, it would have to be residentially clean. At that point, an appraiser could then advise as to what the purported value of the property would be. So it's number one, you would have to confirm the zoning. I would recommend that up front. Number 2, do a phase 2 to determine level of contamination and required remediation. And then 3, at that point, do an appraisal of the property to determine whether, in fact, what's being proposed is doable. And I guess more generally, what is the needs of the community, in terms of senior care facilities, whether that's a need of the community, whether that's something where the market's already saturated, and that would also depend on the location of that facility.
The council and neighborhood leaders are quite upset regarding a property in the Pinecrest neighborhood that is unkept. The grass is several feet high, there are strange smells wafting from piles of materials clearly visible on the property, and there are unpermitted structures on the premises. Previous attempts over the years to bring enforcement action have resulted in a protracted legal dispute that resulted in an unfavorable outcome for the city. Yet issues persist. What advice would you give to the council?
So I guess without really knowing what, I assume when it says prior enforcement action, I assume that means probably issuing tickets. I guess I'd have to wonder as to the as to the capability of the prosecutor to handle that. I mean, if it's this bad and you can't enforce a ticket, then I guess that's the first problem. So maybe the first question is, who's your prosecutor, and you may want to change. But being serious, if the issuance of tickets is not working, something that we have used in multiple communities is through nuisance abatement. And through the local district court, the district court has the authority to, in essence, issue an order that would require either the property owner to clean the property, to abate the property, and if they refuse or are unable, would permit the community to go onto the property and actually do the abatement themselves. And the best part about that process is that it comes through the order of a court of law, which I think shields the community somewhat, because you talk about what risks are involved. Anytime you go on somebody else's property, potentially you are trespassing, and so that's a concern. If you tear things down that we weren't supposed to, then there could be issues of damages to the property owner. That's why those abatement orders have to be very specific, very clear as to exactly why we're going on, what steps we have taken prior to going to court, and exactly what we're going to do when we get on the property. So the nuisance abatement property, and again, the nice thing is you go through the local district court. You don't go to circuit court. And we've done those in Pontiac and Redford very recently. In fact, through Redford Township, we actually got a house torn down because it was such a disaster. And you try to work with the owner, and they show up and they say, "Give me another 30 days. Give me another 30 days." And enough's enough. Neighbors are complaining. And it got to a point where it was a health and safety risk, and that's really almost a standard. Is that there's got to be some health and safety based on this description? I think that we would meet those criteria. If it's just long grass, probably not. But when you have smells and things and other properties, other buildings that are not permissible, I think at that point you could make the argument that there's a health and safety issue.
Actually, maybe not in Highland Park after that one.
Right.
Yeah. Anyway, story question number 3. In 2005, a building alteration was approved by the Building, Zoning, and Historic Preservation Divisions, and work was completed to renovate a 2-unit duplex near downtown. The work completed in 2005 included modifications, including removal of the separation of units, a kitchen, living areas, and adding bedrooms. These changes effectively made it a one-unit rental property. During a routine inspection, a housing inspector noticed that the rental house currently on file, the rental license currently on file with the city is still a Class 3 rental license for 2 units, with each unit being licensed for up to 2. He alerted the housing administrator, who has brought the issue to your attention. There are currently 5 renters living in the building. What actions, if any, do you recommend?
So I think the first step would be to have a communication with the owner to find out whether this was something intentional or whether this was a mistake. And number 2, if permissible, I would have the owner of the property apply for the appropriate rental license. Because if that's accepted, that may potentially resolve the situation. Really beyond that, I think those would be probably the best 2. I wouldn't be in favor of vacating the premises. I would try to work with I would advise the council and or city manager to try to work with the property owner to come into compliance. In terms of strategy on approaching conflicts in code, going back to law school days, typically when you have 2 conflicting statutes, 2 conflicting codes, it's the more specific code or ordinance trumps the more general. So, in terms of how you interpret those, you would look to the more specific to provide you guidance. That's a very difficult situation. And the risk involved is ultimately if it's non-compliant, people who have signed rental agreements who live there, ultimately could be put on the street if it's not compliant. And so, that's just not something good for a community if that were to happen. I think the better way is try to bring the premises into compliance if that's permitted.
By city charter, all contracts must be approved by the city attorney. This is a frequent requirement. Please tell who will be involved in the review and how it will be billed.
Yeah, so there's something about how many hands touch a contract. I mean, if the contract, if I'm the point person, I'm going to look at the contract, and if it's a waste management contract, I would probably refer that to Steve Hitchcock. If it's a consulting contract, myself or Mr. Chubb would handle it, and we would review the contract. We are huge fans of technology. I always like to get things in Word so that I can redline changes. That way, then there's no dispute about what my proposed changes are, and that would be billed on an hourly basis. So if it takes me 2 hours, I'd bill you 2 hours. If it takes me 5, I'd bill you 5. But we never get in the situation where I'm going to review it and then I'm going to give it to Travis to check my homework. We don't do that and then double bill.
I think we'd be worried about Travis because I think he can't even do the swing thing.
That's right.
Nope.
Right.
Failed. Really great parks you can practice.
Right. So I think to me the most cost-effective way is to have one person do it and be responsible for it, be the contact person for it. And I said, I think if you utilize redlining in terms of proposed changes, I think that simplifies it, because when you send it back to the vendor or the person who's seeking a contract, they know exactly what changes are required.
Thank you.
What is your experience handling property tax appeals on behalf of the municipality, and have you handled any major trials in front of the tribunal?
Yeah, Mr. Hitchcock, we currently do tax tribunal work for Pontiac, Highland Park, City of Wayne, Brownstown, Romulus, and Redford. Steve's been in business for 40 years. I can't speak to his. I know he's had major cases in front of the MTA. I'm just not sure how many. We've also had, it says tribunal. I'm sorry, I thought that meant tribunals. But we have had other cases in front of other state tribunals, including Merck and unemployment cases.
Switching gears here to prosecutorial piece. Describe your experience with district court practice. Please include trial court experience, number of cases taken to trial. Also describe any experience with prosecuting cases in other jurisdictions.
So, as I mentioned before, I was with the Oakland County Prosecutor's Office for just under 14 years. When I was with them, I did a stint in district court where I was assigned to almost all of the district courts in Oakland County at different times. And then when I went up to circuit court, those cases start in district court. So I spent time in basically every single district court in Oakland County. When I joined Gianmarco, I added Redford and the city of Wayne, which are both in Wayne County, to the district courts that I practiced in. I've tried many cases, as I mentioned before, probably 30, maybe 40 jury trials, and then bench trials, which I find to be a bit more common in district court than jury trials. Sometimes they go to jury, but not quite as much as in circuit court. But bench trials, hundreds of them. I'm very comfortable in district court. I like district court. A lot of times when you're in circuit court, you get people who are just kind of career criminals, and in district court, a lot of times it's someone's first time, in the criminal justice system, and you really have an opportunity to kind of get some intervention in there and make a difference in people's lives. And then also in district court, you get things that are not serious crimes, sometimes like traffic tickets. So you have a chance to just meet regular citizens who, just made a mistake, or they were speeding, and it's their first time in court. And it's just kind of a different experience than being up in circuit court. I love district court work. It kind of always feels like a family.
You want to talk about MIDC too?
Yeah, so I also, the MIDC is the Michigan Indigent Defense Commission, and I'm involved in that as well. I was actually the first manager of that for a district court in Oakland County for Ferndale. And then after that, I picked up a contract with Oak Park as well. So I do all of their grant work on the MIDC and run those programs for both of those courts. And so that's just making sure that anyone who's indigent in the state of Michigan has representation. And really before, you would get court-appointed attorneys where there was a lot of fees associated, and there weren't court-appointed attorneys at arraignment. So people were coming in and being arraigned without a lawyer, and that's really a very important part of the process. That's where bond is set, bond conditions. Some people felt like they had to plea at that point. And so now there's an attorney, honestly, regardless of income, for everybody at arraignment. So I have a lot of experience. I've been working with the MIDC since they first rolled this out in 2018.
And I think that ties in also with the racial justice piece of it that I probably should have mentioned up front, but certainly that's a huge part of it. So, sorry, Carrie.
Oh, that's okay.
Next question. How does your experience as a criminal defense attorney benefit you if selected to be the city's prosecuting attorney?
So I've never practiced as a criminal defense attorney. So my entire career has been prosecution. So if I came in as your prosecutor, it would just be with many, many years of experience as a prosecutor.
Yeah, I think the only criminal that I've done is probably handling my son's friend's traffic tickets in court. I seem to get a lot of those,
What is your experience with alternatives to jail, such as special status designations, deferred sentencing, treatment courts, and then can you provide examples of cases that you and your firm have handled that fall under these categories?
Sure. So I have a lot of experience with that. I've worked in drug treatment courts, sobriety courts, mental health court, and veterans courts, which are all alternatives. So under any of those programs, and I'm not sure which ones you have in East Lansing, but you may have all of them, someone can come in and they would plead guilty and they would go under like a very heightened probation that would take into consideration all of those issues. Like with veterans, a lot of times there's PTSD issues, sometimes issues at home, sometimes substance abuse, and they would really treat the person for their specific background. And then usually you can earn a dismissal of that charge. So it's an incentive. I've also worked with a lot of different deferral programs. There's 7411, which is like for a first-time drug user, where it's a chance to get it off your record. 771.1 is a deferred sentence that a judge can give, where someone would go on probation, they'd be able to earn a dismissal. There's also something very similar under domestic violence law. minor in possession, which you probably see quite a bit at the university. There's deferrals there. So I'm a big proponent of deferrals. You know, it really gives someone an incentive to fix whatever issues got them in the criminal justice system to begin with, and tools to do that, especially for first-time offenders, and then an incentive to get that off their record so that they, can have a future and be able to apply for jobs and school and things of that sort.
Considering jail reform legislation, what support mechanisms would you consider in a plea agreement to allow for successful completion of a court's judgment?
So again, deferrals is a big one. Probation, community service. As far as going into, when I look at something and I'm thinking about, a reduction of a crime, it usually comes in a victim, if there's a victim involved, in talking to the victim, any kind of restitution, if their ability to pay that off, to make a victim whole. Again, if this is their first time in the system or first offense, that would definitely be something that I would take into consideration in making a plea adjustment. Payment plans, things like that, but I think that, jail overcrowding and jail reform is a really significant thing that we're moving towards in society now, and I think it's important. So if there's any opportunity to use probation or other ways to help to avoid repeat offending, that's something that I would always be willing to work with the court on.
Okay, thank you.
Please explain what factors you would consider when offering a plea agreement. How would you balance the need to deter future violations and someone's inability to pay fines and costs?
So whenever, I'm looking at a charge and I'm thinking about a plea reduction, a lot of things come into play. Usually the first thing is their prior criminal history. If someone's there and this is their very first time in the system, it's a bit different. Then their age, and then the severity of the crime. If there is a victim involved, like I said, I would always want to talk to a victim and get their input. If there's any restitution, I have a case right now in the city of Wayne where someone drove and they hit a pole and it cost $5,000, and the city wants to recoup that. So, this was a hit and run situation. It wasn't involving alcohol. So, in that case, I'm considering reducing it from a failure to stop to a failure to report, and that would be 6 points that would not go on their record. It's still a misdemeanor, but my condition is you have to pay the city $5,000. So as long as they're willing to pay for that, they can get a reduction. So I would definitely take into consideration things like that. When it comes to ability to pay, that would really be something that sometimes tickets or things of that sort may have many counts, and when you're dealing with someone who's not going to have the ability to pay that, I usually don't have too much of a problem dismissing a few of that so that it's reasonable and the court can actually collect, instead of multiple show causes and the court's not able to get any kind of money at all. I would definitely work with the court for any kind of deferral, like I said, or community service-based things for people who can't pay, I think is always a good option as well.
I asked a question. How can you ensure, it sounds like you're the primary on the prosecution side, and that your assistant prosecutors or whoever steps in your absence would adhere to charge and plea bargain policies established by this council?
So I would just plan to have a really open dialogue with the council so that I understood what the council's interests were when it came to prosecution, and then I would view myself as the point person or direct supervisor. So anyone that was prosecuting in the court, if it wasn't me personally, would know the guidelines, and I would have an open communication with them in case they needed to bounce something off of me to make sure that we're prosecuting in a way that the council finds appropriate.
Any open questions from council?
Good question. Just similar to my question before. So I work in public health, and we've been going through like implicit bias trainings, and so has the city of East Lansing. Like a number of our employees and departments are going through implicit bias trainings. So how does your firm offer those trainings, and have you all been involved in implicit bias trainings?
What was I'm sorry, the kind of training?
Implicit bias?
So, yes, we do offer all kinds of trainings, including implicit bias. And I have done, it's been a little while, but I have done implicit bias, harassment, discrimination, hostile work environment. In fact, I just completed training the entire city of Taylor, which is over 500 employees, in all of those categories. So that's something that I've been doing for most of my career. It's something that I enjoy doing. I really enjoy the dialogue with staff. And I also encourage councils or boards to also participate in those trainings. I think it starts at the top. So I think it's important that everybody be involved in those trainings and that those be available. Because in some communities, I do it every year. Even though it's the same training, because it's important that you can't be trained too often, I believe, and things come up and things happen. So I think it's important to have that resource available. And we also do handbooks. We do a lot of handbooks for communities, which kind of ties in with training and policies, kind of go hand in hand.
And just a clarification question. I don't know if do you all have your booklet?
Yeah, I have it here, yeah.
Okay. So I'm on page 29 that talks about the rates.
Yep.
And then on the compensation tab, which is page 27, that's a different rate, right? I'm reading that right.
Let me take a look.
I think it was 135 on the compensation and 45 on the rate.
So 135, so I apologize.
Okay, yeah, that's okay.
Yeah, and the other thing, actually, I'm glad you brought that up, council member. We are always happy to discuss and entertain a retainer for certain services. It's just impossible without knowing the magnitude of work involved.
Mm-hmm.
It's real hard to come in and say, yeah, I'll do it for 40 grand a year. That may be a great number. It may be a great number for us.
Yeah.
Well, right, yeah. So.
We'll give you 42.5.
Oh, you got it. All right, let's go. No, but it's difficult without really knowing the work involved to come up with a number that's solid. But certainly, if a relationship happens to come together, certainly after a handful of months, I'd be happy to revisit that. And if it makes sense, maybe for part of it, we do retainers for just the general municipal work. Anything that's adversarial, litigation would be hourly. We have for Redford Township, we actually have a retainer for all the prosecution work. So we're happy to entertain those, again, depending on the volume and depending on the number, but we're certainly happy to entertain those at some point during the relationship.
I want to make sure I understand what you just said.
Yeah.
So all of your rates are on the hourly basis that's in the prospectus.
Yeah, correct.
And it would include litigation.
Correct.
Civil litigation.
You got it.
Thank you.
Yep, 100%. Everything would be 135, regardless of what we do, with the understanding that we'd be willing to entertain a retainer in the event that works out for both sides.
Thank you.
Sure.
And you did, just to clarify, you did say that you would be willing to take on just the municipal side of this if we did retain a separate prosecutor?
Absolutely.
Okay, great.
Yep.
And I'm sorry, the inverse question.
Absolutely.
You take on simply the prosecution side if we went with someone else for the municipal.
Absolutely. Absolutely.
He started with whatever we can get.
I don't like to beat around. I don't like to beat around the bush.
These are my people. Whatever you can get.
That's right. That's right. Thank you. Appreciate it.
I'm going to make a request of council here to kind of invert the next two. I think I wanted to put Mr. Easterly next, so we can put a natural break back into his presentation. Portion of that. But are we prepared? And then we'll go to Clark next.
Thanks for coming.
Pleasure. Appreciate it.
Thank you.
Thank you for your time. Thanks for coming.
You don't want to stand up.
Well, great. Thank you so much. I appreciate it.
Very nice to meet you, sir.
I was up last night. I actually went to the game last night, so I was up here last night.
Nice to meet you. I wanted to tell you to put on your coat because it's so hot. And some of these Phoenix is not very warm.
Yeah, I just saw that.
Very nice to meet you.
Where's George?
Should we wait? Does he understand?
You can start. Same words, flowing. But I guess we do an intro here and then go into questions. We can start right with question 14, correct?
We would just skip all of the, well, let's clarify. Yeah. Hello, Mr. Easterling.
How you doing?
So just to clarify, you are, your proposal covers only the prosecutorial services, not the standard municipal. Okay, great.
That's correct.
So we'll do our general introduction questions, and then we will skip all of the general city issues and jump right into prosecution.
Okay.
All right. Obviously, we have your proposal, and should probably state that we have been working with you because you are the prosecutor for sponsorship that's currently working for us. So we are a little bit more familiar with you than other folks, but I don't know if we've actually had a chance to talk specifically for a while. So why don't you just go through your qualifications and experience anyway? You really know some of it.
Absolutely, thank you. I've been with my current firm for a little over 6 years. My background has been in, I did do some civil work at the beginning of my legal career, but primarily my career has been criminal defense and prosecution work. Obviously, for the last year or so, my primary responsibility has been the prosecution work for the city of East Lansing, which has included really building relationships with all of the stakeholders in relation to that, and so working very closely with the court staff, the judges, the police department, the obviously criminal defense attorneys in the area, the probation department, all of the stakeholders that come into play. Had the opportunity to review and draft changes for ordinances. I've had the opportunity to really work with other stakeholders like ASMSU, those types of folks who are quite frequently coming through our system. That's
Great, thanks. I'll bump it over to Ryan.
Describe your experience with district court practice. Please include trial court experience, number of cases taken to trial. Also describe any experience in prosecuting cases in other jurisdictions.
Absolutely. So district court practice, I think I've practiced all across the state in district court. In terms of volume in specific courts, I've held contracts in 2 courts in the state for public defender work. I worked down in 55th District Court as I started to shift my practice to criminal work. I took a public defender contract there, worked primarily in Judge Allen's courtroom, Judge Boyd's courtroom at the time a little bit. Did some of the first appearance stuff, and then obviously handled a caseload there. I also had a contract with the district court in Eaton County, also doing public defender work. Was in all of the district court courtrooms there as well. One of the things about being in district court is it's not just doing the prosecution or the defense work. It's really knowing how that court operates. When you show up to district court, to a district court you haven't been, one of the first things you do is walk in and find somebody who does and say, hey, how does this judge do this, or how does this court staff do this? And so, being able to be involved with a court that intensely and understanding and knowing how that court operates is huge. And so, obviously, having done that in East Lansing, that's been a benefit for me as well. In terms of cases taken to trial, I've been first chair on 3 trials. I've never taken a civil trial a civil case to trial. What was the rest of the question? I think you gave me 2 or 3 there.
Maybe other jurisdictions, experience in district court practice, trial experience, courses taken in trial, and then in other jurisdictions.
Okay. Yeah, I think I mentioned other jurisdictions in terms of having contracts in 2 other jurisdictions at different times. I've also done prosecution work in 2 other jurisdictions. I did prosecution work in support of other partners in my firm for the city of DeWitt and the city of Fenton.
How does your experience as a criminal defense attorney benefit you if selected to be the city's prosecuting attorney?
I think in a couple of different ways. I think, one is certainly there is some degree of tactical advantage. But aside from that, I think, the opportunity to kind of have just a broader perspective of things. One of the things that's important, I believe, is to have balance and to not be so much of a one track that it's prosecute at all costs or it's defend at all costs, but to really understand what's important, what the values and what's important and what people deal with and how to relate to people. Relationships are also important. Most cases in district court are not going to trial. They are going to resolve, and having good relationships and having someone who knows that if you say, that you mean what you say, number one, but if you've got the strength of a case or a weakness in a case, then, and they know who you are, they know that that you are, ethical in what you do. I think that's also a huge benefit as well.
What is your experience with alternatives to jail on clients' behalf? Mr. Brookover amended that question earlier. For instance, special status designation, deferred sentencing, treatment courts.
I think I've dealt with pretty much all of them. So there are deferral, outright diversion programs where someone will have an opportunity pre-charge. You may review a case and decide before charging and putting it into the court system and provide an opportunity for someone to make amends in that way. There are all types of other treatment courts. I currently sit on the Ingham County Treatment Foundation Board, and so I've got heavy involvement with sobriety courts, drug courts. I haven't had quite as much interaction with the veterans courts, although East Lansing has actually given me that opportunity. But there are all types of diversion opportunities. HYTA, which is for people who are 25 years of age or younger. There are drug diversion programs. There are domestic violence diversion programs, although I know we don't deal with domestic violence at the city level here. But there are quite a number of opportunities. We do, in East Lansing, we do quite frequently do an opportunity for someone to have a deferred sentence or a plea under advisement that says, we've got a student made a mistake here, 6 months or a year staying out of trouble, do some community service, go through counseling, those sorts of things, and then the case is dismissed on the back end. And so there are a lot of different ways to fashion those types of outcomes and alternatives to jail.
Considering jail reform legislation, what support mechanisms would you consider in a plea agreement to allow for successful completion of a court's judgment?
Many of those things. One of the good things, one of the things I love here in East Lansing is you've got a really good probation department. And so, one of the things that your prosecutor, although they should have their eye out certainly for where there's a need for services or support, you have professionals in the building that's what they do. And so having a good relationship with your probation department, having a good sense of what services are there and around are huge, I think. Other things that you take into account are, people's criminal history, certainly people's age, any other mitigating factors that might have, that might be present in the case. Certainly if there's a victim or, what type of harm has been caused, those are the types of things that you would take into account.
Thank you.
Please explain what factors you would consider when offering a plea agreement, and how would you balance the need to deter future violations and someone's inability to pay fines and costs?
Sure. Plea agreements, many of the same things. So certainly someone's criminal history is one of the first, places that we're looking. Someone's age, what harm was caused. Is there a victim? Is there restitution to be sought? If there's a need for support or services, these are all pretty huge things. It's been interesting recently in terms of balancing the need to to deter future violations and someone's inability to pay. It's been a little bit interesting, I think, recently in that context because, we used to use community service quite a bit. And with COVID, you haven't had that sort of an opportunity. And so we've done things, that have given someone an opportunity to have a different type of experience, perhaps a workshop or a set of counseling, those kinds of things. You can also, we work very closely with the clerk's office and with the courts to fashion opportunities for people to have payment plans and, different things of that nature.
This is the last official question. How can you ensure that the primary, you do the primary, and then however this is going to be fashioned later, related, when you bring the formal thing forward, assistant prosecutors will adhere to the charge, plea bargaining policies established by counsel?
Well, I think it starts with making sure that we've got a good, clear, an open relationship with counsel to understand, exactly, for counsel to understand what we're doing and for us to have a good understanding of what it is that's important to counsel. But in terms of ensuring that that's adhered to, I would be the primary, and we would make sure that there is that those policies are very clearly spelled out. But also, we take a group approach to reviewing cases. And so, weekly taking a look and saying, where are we on these cases, and having a good review system in place for those outcomes.
That's a phone question. I'm going to open to counsel for open questions, and I'll start. I have got an open question. Technically, you're incumbent in this role, but in a way, with what's the judgeships and the changes that are going to come over, that incumbency may not grant the full advantage that it would. You mentioned early in your presentation about, getting to know the courts and understanding that it could be, it's either a 50% new court or it could be 100% new court based on what happens this election cycle. So what's going to be your strategy to, if we say, let's hypothetically say it's 100% new court when you come back from that election, what's your plan? How are you going to build culture and do that stuff?
Thank you. Well, I think no matter where you are, no matter what system you're in, it's the support folks, the people that you have around you that really make the wheels turn. And so hopefully we would never have a 100% turnover in our court staff, our clerk's office, our court administration. And so having some continuity there is huge. And, but beyond that, a new judge hits the bench and begins to establish, at least for their courtroom, the way they do things, the important thing is to develop relationships early and often. This was a tougher year in doing that that it was a pandemic year and that we were not in the building as frequently as we would like to be, but very much looking forward to continuing to develop relationships in that way.
Any questions?
I have a question. So, you've been with us for a little bit, and there was a time that you were brought into a meeting with City Council. And one of the things we were discussing is the racial inequities, which we see in the city of East Lansing, in Lansing, all across the board. And so I was wondering, as city prosecutor, where do you see your role at in impacting those inequities so that they can be eliminated at some point?
In a number of ways. I think, the best way to, and I think there was a question, earlier about, racial justice work, right? And, one of the biggest ways of championing that, no matter which side of the V you're on, is just to do your best to ensure that someone is treated fair once they enter the criminal justice system. If you're defending, whether you're defending that person or prosecuting them. Scrutiny as it relates to charging is huge. We have the opportunity to take a look at, trends as it relates to, how people are charged, how people are stopped, how are they even initially in, how do they find themselves in the criminal justice system. And, keeping an eye on that and understanding what the trends there are is a big part of that. Recognizing that when you see inequity in charging, addressing that. And then making sure that outcomes, that plea bargains, for instance, are fair and equitable. I've had an opportunity over this last year really to talk with police officers about some of the things that I've seen. I've had an opportunity to talk with counsel about what I've seen, and I've had an opportunity to talk in the courts about some of the things that I've seen. And I think the biggest thing is to have your eyes and your ears open and to do what's right and what's fair as far as people are concerned. That's what, for me, that's what justice is about. And so while you would be looking at factors in a case to determine, what should be how you should operate as it relates to that case, one of those factors should not be race. And so when you see differences as it relates to that, there's an issue there that must be addressed.
Open questions. The floor is yours. If you have any closing statements, go to break from there.
Just very grateful for the opportunity. I've truly enjoyed working with pretty much everyone in the city of East Lansing. It's a great place to work, and I'm also have been very proud of the leadership that's allowed for that to be the case. And so, thank you.
Thank you. Clerks on deck. What's that?
Gray wall.
Okay.
Gray wall.
Three walls on deck. 15.
Thanks, Ben. Thanks for coming in. Good seeing you.
7:45. 7:45. Get everybody out of here.
We're good.
Oh, yeah. I'm on deck. Well, welcome. Thanks for sticking it out with us, you guys. Save the best for last or some. So obviously we've looked at your two different proposals. So do I have two copies, or we've got one of them as an addendum? Or is it just one? I think I've got two copies.
Yeah, it should just be one.
Okay, so just one. But could you just briefly explain your background and experience as it pertains to the citizen of the city?
So, my name is Mick Graywall. I'm the owner and founder of Graywall Law. And I apologize, I'm going to try to speak a little slowly for my asthma purposes with the mask on. I've been practicing law for almost 29 years, pretty much in every area of the law. I founded Graywall Law for the sole purpose of making sure that the community in general had competent, zealous legal advice for pretty much everybody. Being a minority myself and a minority owner of my law firm, I knew this was very important. I was raised with a background of Sikhism. I don't know how many of you know about Sikhism, but I'm a Sikh, which is my religious belief, but we believe in equality for all. And that's men and women, every race. And this is how I founded my law practice. All the people that work for me are part of my family. I have a lion logo. They are all part of my pride. They're all lion and lionesses. Sitting here with me today is Dan Bernat, Tim Seeger, and Ayanna Neal. There are 13 attorneys that work for the law firm, and what I propose in our prospectus that you have is a team approach. And the reason I propose a team approach is not because you have to worry about double billing or anything like that, because I understand the caps and we're happy to talk about caps. But I think in order for the council to have adequate representation, you have to have a large team. You have to have people that will back you up, to give you zealous advice, and at the same time, service the community. And without servicing the community, all of us together, we're doing a detriment to our society. I want to be very clear on one thing, though. I'm the owner of the firm, and these 6 people, because I have 3 more attorneys right there, they have the backing of me. You don't have to go to a board, you don't have to go to anybody else. They have my 100% backing. But I am not going to be one of the people as a city attorney or assistant city attorney. I just want to be very clear with that, because the work that I am predominantly doing right now is dealing with sexual assault across the nation, and specifically in Michigan, trying to change the law. I don't want any misrepresentation at all pertaining to that.
Thank you.
And Dan, go ahead and introduce yourself.
Sure. Thank you. My name is Daniel Bernat. I'm the team leader for civil and commercial litigation at Graywall. I'm in court a lot. I have a lot of litigating. A lot of trials coming up this year. And I graduated from Michigan State University. I was a teacher before that. I taught for several years, was a band director, Decided that it was my two interests, and decided to go to law school. So I graduated from Michigan State, and then I actually worked first in East Lansing, just down the road, for Andrew Abood, and then kind of met Mick when we were working on the Nassar case. And and now next month will be 3 years with Mick. Very happy to be here, and I would be kind of advising on the litigation aspect of the team.
You guys are so big. What we'll do, we'll just combine this question with question number 2, because the next portion. Who would serve as lead attorney when we get to you, and kind of what your role will be, and then kind of you can speak to response time and availability in that role at the same time. You guys are a little bit bigger than the other firms.
So we'll split that up, and I would serve as city attorney as far as anything litigation. And honestly, and I'll talk about this a little bit more later, but trying to stay out of litigation, because even though I'm a litigator, that's not where I want to be, and it's not where I want you to be. So I would be available then. My cell phone number is on my business card, and that's not just for you, that's for every client. That's how I operate, and my response time is, unless I'm in court or in a meeting where I can't look at my phone, my response time is the next time I get to look at my phone.
So my name's Tim Seeger. I'm another attorney, obviously, at Great Wall Law. As far as the roles within city attorney, I would be leading for the municipal issues with regards to zoning, ordinances, as well as general contracts. My background, just to kind of encompass it, because Michigan State was brought up, I went to college at the University of South Carolina. Went to law school in San Diego, California, where I met my lovely wife, who was originally from the Okemos area. Practiced law in California for 5 years, and then was convinced to come back to Michigan, well, to move to Michigan from San Diego. I have been practicing here for almost 3 years, exclusively with Mick. A large part of my practice is employment law. I have represented, obviously, a lot of private individuals regarding civil rights, Title VII, Title IX as well. But also a lot of public employees as well, at the federal, state, as well as local level, including even some different departments, from the lottery to health services. I have quite a wide array of a practice. I somewhat joke within the firm, I'm the Swiss Army knife. When there's an issue that needs to be solved, it comes to me. I've represented a lot of individuals with municipal issues. Just recently, I was with the historic district regarding Boyne City in an appeal that was being resolved there. I have extensive experience with regards to advising clients as well, primarily from the employment aspect. Cheyenne, who's here as well, runs our marijuana department. We help businesses get set up, licensed throughout the state. I'm also helping with them and coordinating with them. A lot of times first-time business owners, making sure they understand the rules, the regulations that they need to adhere to, both from the employment setting, but also safety protocols and things of that nature. As far as response time, I do live in Grand Rapids. As far as phone calls, I'm readily available. I would be primarily focusing almost 100% of my time, with the exception of a few employment law cases, as being city counsel or city attorney to the council. And there's space within the Okemos office where I probably would be there, if not 80% of the time, just so I could be here on a drop of a dime if there was an immediate emergency that was needed, because I can conduct almost all of my practice from the Okemos office as well.
And let me bring one thing up, Mr. Mayor. Our proposal is only with regard to the municipality. I did have a chance to speak with Mr. Easterly prior to this, and he put his bid in with regard to the criminal, but we do have a criminal practice. Ms. Neal's in charge of that practice, if there's any questions pertaining to that. And if there is a package deal, meaning Mr. Easterly gets that criminal package and I continue to negotiate with him, we can actually assist his practice. And Ms. Neal's here to talk about that if needed.
Can you get him down to $135 an hour?
For you, George, yeah?
Interview's over.
Good evening, Council. My name is Ayana Neal, and I've been practicing law for almost 20 years. I currently serve as a senior attorney at Great Wall Law, and I am the team leader for the criminal and the family divisions. I've been working at Great Wall for almost 3 years now. It was an honor and a privilege for me to go from government work to join the Great Wall firm, because it was very important to me, not only as it relates to the integrity of Mr. Greywall, but also him being a minority business owner. With the amount of time that I spend in court, I frequently see people that are of color, and unfortunately, even today in 2022, there just aren't enough people of color representing people in the court. Prior to working at Graywell Law, I served as an assistant prosecutor for Ingham County for almost 16 years. I was the arson prosecutor for about 9 years, the major drug prosecutor for almost 4 years. I handled almost 100,000 cases during my tenure as an assistant prosecutor, handled multiple trials. I worked at all the court levels, district, circuit, as well as family. I currently do family court work as well as probate work in some civil cases, and I also do criminal defense as well across the state.
Diversity, equity, and inclusion are not just words in the city. What racial justice work has your firm been involved in, and how does diversity show in your firm, and how does inclusion matter? And I know you all have touched on some of it.
I was raised that way, Councilwoman, and as you can see right now, with half my firm right here, we have a diverse membership. They have 3 out of the 13 attorneys are women. 4 out of the 13 attorneys are members of different races, 2 Asian, 2 black people. In the end right now, I am a firm believer that society needs to change, and we are the people that are here to help society change. As Neil just stated, I've been in court so many times and I see the inequity. And without the ability to go out there and advocate on behalf of these people or on behalf of the council, inequity is always going to be there. So I pride myself on having attorneys who are very zealous in this. And I don't know if you want to add anything else.
I would also add that it's been very important to us in the work that we do that we are representing people of different racial backgrounds. I can indicate that we participated in pro bono work, including participating in, I believe it was sometime this summer, I think it was August or September, in the expungement clinic that was done through the East Lansing District Court, and I've also participated in other pro bono expungement clinics to help marginalized people as it relates to clearing their record, as well as it's been extremely important to me to work as a, I guess, contracted public defender for Eaton County. Because again, there are also many people that go to court in that county, and they are a multitude of people of color, and there just were not similar numbers as it related to advocates or attorneys to represent those individuals.
As city attorney, you must have a good understanding of the city charter and city ordinances. Part A, do you believe that it is important to enforce the city charter and ordinances even when enforcement may be contrary to an outcome desired by the city council or city staff? And Part B, using the city charter as your guide, what is the nature of the relationship between the city council and the city attorney, and the nature of the relationship between the city council and the city manager?
So I'll address that, and I think the first thought is, you're my client, right? I am constantly brought, whether it be a civil matter, family law matter, of people saying, hey, I want to do this, but the law doesn't align with that. The reality is we have rules, we have ordinances, we've got to follow these rules and these ordinances. With that being said, I go to all of my clients and speak to them, what is your desired outcome? Here you're saying there's a goal we have, but an ordinance is in conflict with our goal, that if I enforce what is currently our rule and regulation, you're prevented from doing your job. Well, that's an issue. We've got to figure out what that is. So from my point of view, from the very get-go, I've got a concern, which is I haven't done my job because you have a desired outcome and you can't achieve that with the rules and ordinances that are in place. I haven't done my job to make sure you're informed as to the rules and ordinances in order to achieve your goal. We're looking at a goal of, let's say, diversity and inclusion, which is a common topic that is being raised here today. If there's an ordinance that's preventing that, I view that as a major issue. I view that as a big concern, and we need to discuss how are we going to affect that. Do we need to change that ordinance? Do we need to effectuate change within, whether it be through voter approval or anything of that nature? So I think it's a joint effort of making sure that I'm coming to you like I do with all my clients, that you're making informed decisions and ensuring that we are furthering the city, bettering the city, and doing so within the guidelines we have set out, as we would all be public servants. And then I believe Dan was going to discuss with the relationship with the city manager.
Sure. So I see this as similar to, we're officers of the court when we go to court. We're officers pursuant to your city charter of the city. The city manager is the chief officer, so we are to work in conjunction with the city manager and report to you. But you are the client, and we are officers to try. You're duly elected. You have the people's best interest in mind. We are officers of you, of the city, to try to effectuate your purpose for the city.
Please state how many criminal and/or civil jury trials each member of your proposed team has tried to a verdict.
I have had between 60 and 80 jury trials.
I'm not going to compete with her because I'm not on the team.
I know you're not.
I have one jury trial that has gone to verdict.
That's the same. I've had 8 jury trials, but only one that ever went to verdict. The rest we resolved during trial.
Thank you.
And I'm going to combine the next 2 questions for simplicity. Please state which members of your team have presented oral argument before the Michigan Court of Appeals and also before the Michigan Supreme Court, and on how many occasions.
I guess I'll start with that. I've done 3 in front of the Court of Appeals. I have 4 cases in front of the Court of Appeals currently that will be set for oral, or well, 2 of them are set for oral argument. The other ones will be. I have not argued in front of the Supreme Court, but I have argued in front of the federal district courts and the 6th Circuit.
I've done 2 in front of the Michigan Court of Appeals. If you are looking for an enthralling discussion regarding premises liability, you can go to the January 11th Court of Appeals YouTube page and look at panel 6. I think it's somewhere around an hour and 26-minute mark, and you can watch that lovely debate. I have not been in front of the Michigan Supreme Court. I will add I did do one in California as well.
Here's a story problem section again. You guys had open book because you're already right here. Developer has approached the council regarding a 4-acre city-owned property in the northern tier they'd like to redevelop into a senior care facility. The property recently became the city's as part of a gift to the city and is not currently listed for sale. The former use of the property indicates that there may be some environmental contamination on the site. The developer has stated that they would need to utilize brownfield tax increment financing to address the site contamination that may exist. What factors would you recommend the council consider in response to this request?
So the initial factors look to, before we get to specific zoning as to whether it's residential or not to get there, is what is the purpose of the land that can be done? This is donated land, or at least it was a gift. A lot of times that can come with specific restrictions, whether and how it was bequeathed to the city or how it was presented. We may have a restriction that before we even get to an analysis of the tax increment financing or what it can be used for as a senior home, we might stop the conversation right there. The last thing I'm going to want to do is waste the council's time giving you all the other analysis if I'm brought to something that says, oh, well, this can't even be done. Presuming it can be, that the donated land is allowed to have that purpose, we're then going to look into the contamination and whether or not it's even eligible for brownfield financing. With regards to the contamination, I would advise obviously doing an environmental assessment, and can this land even be restored to allow for a senior home to be there. I think there's initial concerns with regards to what the nature of the contamination was, and will we be able to have a safe senior home be on that premises. And then we even look to see from there, is it eligible for brownfield? I presume this would qualify as a blighted property within the standard set out for the brownfield board, which I know obviously the mayor is a member of. We would need to make sure it qualifies into one area. It's not in the downtown development area, being that it's in the northern tier, so we're going to have to establish that it's a contaminated property. Obviously, again, presuming that it is something we're going to want to look into. Again, the nature of the contamination, is it going to need to be cleaned up? Are we going to be able to get it to that level and even then qualify? Even if we establish all of those, so okay, those are our first levels of consideration, we then want to look and see if it's eligible. The good thing is in the northern tier, because the northern tier is pretty much set up with its stated purpose, that the strategic goal is to have a mixed usage for residential facilities. Again, I don't think these are going to be hurdles that are going to come through, but as we kind of analyze all of this, because then we're going to look to zoning specifically. Is that zoning going to allow for that? Being in the northern tier, more than likely it will, and or it'll be easy to shift it to zoning. Lastly, then we're going to look at the buyer and the potential sale. So we've got all these factors. We're finally going to get to that. Who is this buyer? What is their purpose that they're looking for? And with regards to the sale, the reality is under 4.81 of the charter, we're going to have restrictions. I presume, being 4 acres, it's going to cost more than roughly $190,000, which would kind of be the benchmark given the last census. And so we're going to have to list it for voter approval. And what's the process going to be there? So that would be kind of my initial, I know there's a very short list of check marks the council wants to look for. There's also then all of the ancillary concerns that I think the council would have, which is, is this the proper usage? What's the voter perception going to be of this usage and how we're going to put it forward? I think that as much as it's legal, it's also non-legal and a concern for the constituents, and so can address that. But I think those are the primary analysis we would want to look for with regards to, is it eligible and can it even meet the requirements?
You're the first person to acknowledge the nature of the gift, which I thought was like a trick, as I'm not a lawyer, but
I haven't had to do a bar exam in a long time, but it sure helps.
Anyone going to acknowledge this? Can we even do this? You said it, yes. Pass, whatever. Good job. Payment number 9.
The council and neighborhood leaders are quite upset regarding a property in the Pinecrest neighborhood that is unkept. The grass is several feet high. There are strange smells wafting from piles of materials clearly visible on the property, and there are unpermitted structures on the premises. Previous attempts over the years to bring enforcement action have resulted in a protracted legal dispute that resulted in an unfavorable outcome for the city. Yet issues persist. What advice would you give to council?
So the first thing, I'll take this question, and the first thing that we have to do is a little bit of research into why. Why was it protracted? I mean, protracted is a word that's not going to be used under a normal legal proceeding. So what protracted it? And then secondly, why was the outcome not favorable? And that's especially concerning considering, I believe it's section 50-33, article 3, basically states that if you have a building that's erected contrary to the zoning code, then it's per se a nuisance. And if it's per se a nuisance, what legal path did we take that didn't give us a favorable outcome? So we have to make an assessment first, okay? And that's going to be step one. Another thing in that assessment, I think we would go to the code enforcement and see which code officer was out there, what they did, try to align that with the court documents to see if there were issues there. But step two, I think that we have to step outside of the legal realm for a second and start to make a human assessment of what's going on. Because first of all, I understand there are tempers right now, but this is still a resident of our city, right? We have to take heed of the fact that we have a human resident in our city. And I always say that negotiation 101 is to make sure that you take emotions out of business decisions. But I think negotiation 102 is try to find the real source of the issue. And a lot of times it's not what you see on paper. It's something else. And just a quick example of what it could be here is, did the homeowner have a former spouse that erected that statue and used it maybe as a greenhouse or something and then passed away, and there's a lot of sentimental value to that structure? Maybe that's not it, but I'm just saying that there's sometimes always an alternative. And the only way to find that out is to sit down and speak with them. And they may have an attorney here since they went to a legal suit, but maybe you speak to their attorney, maybe you sit down and speak to them and try to find out, is there a way we can work with you? Is there a way we can avoid this future litigation? One thing that I think is also important is, besides that sentimental value, when we sit down and talk to them, do we find out, are there mental or physical health issues involved? And if there are there resources that we can use to help them? I think that's something that at least has to be assessed. Another thing, so one of my trials that went to at least a directed verdict, I won't give you a long summary, but basically it came down to there was 2 words in the statute that weren't defined, and that's how I won. And it was a small technicality, but it was, that's how it worked. Is that what happened in the protracted legal proceeding? Was there something similar that happened there where we could tweak an ordinance or amend an ordinance to fix that problem? So we're going to take all of those aspects, and then we're going to summarize it to you at the end. Here are your options. Here's what we discovered from meeting with the homeowner. Here's what we discovered looking through the reviewed court process. Here are your suggested steps. And again, one other thing to consider, the city ordinances, the nuisance ordinance, civil infractions, do give the court equity powers of fines and jail time. The council is going to have to determine what their image is going to be, right? I mean, if we have a mental health person, I don't think that placing them in jail is a great idea. But at the same time, you know, if this issue persists and it's just seriously a problem, there's also the thing that if a court awards costs and fees and fines and they don't pay them, you can put a lien and foreclose on the property. So all those things need to be considered, and we need to make the best decision in the end.
And I know the council would probably like to move forward to the next question, but one point I want to add, because there was some risk factors addressed there as well. The biggest risk factor I see, given it's already been protracted, is bad precedent. Are we going to go through a long matter with this individual just for them to be successful and allow them to then have this piece of thing, whatever the obstruction may be, on their property? Which means the next person is going to be able to point to legal precedent and say, here it is. I bring up the city of Boyne that I was just there before. It was a civil infraction, $150. I was arguing statutory interpretation and constitutional law because this family, to Mr. Barnett's point, had been in a long battle with the city and knew that if this wasn't going to be successful, this was going to be used against them. I needed to set the precedent that we could accomplish this and allow it to go forward through the historic district. So I think that's another big risk factor that we want to make sure we're assessing.
If it goes bad, I just blame George. Number 10.
Another story question, although I'd love to hear more about Boyne. I started out as a Navy reporter at the Petoskey News Review a little bit. So I covered the Charlevoix City Council, Boyne Falls,
the Charlevoix district judge was not happy with the amount of work I put into that matter, but yeah. Again, Constitution statutory interpretation for a $150 civil infraction probably shouldn't have happened, but.
Is that, the judge is the kid of Hayes?
I think so. I was going to say it starts with an H, I think.
Yeah.
Yeah.
Yeah. I knew his dad was a really class act. So anyway, in 2005, years after I was in Petoskey, which is age, I think. In 2005, a building alteration was approved by the Building, Zoning, and Historic Preservation Divisions, and the work was completed to renovate a 2-unit duplex near downtown. The work completed in 2005 included modifications, including removal of the separation of units, a kitchen, living areas, and adding bedrooms. Excuse me. These changes effectively made it a 1-unit rental property. During a routine inspection, a housing inspector noticed that the rental license currently on file with the city is still a Class 3 rental license for 2 units, with each being licensed for up to 2. He alerted the housing administrator, who has brought the issue to your attention. There are currently 5 renters living in the building. What actions, if any, do you recommend?
So I'll take a shot at this one as well. The first one's going to be very similar to the last one. We have to make an assessment. First of all, it strikes me odd that we're 17 years in now and we have our first violation. So we have to figure that out. Was it simply an oversight by previous inspections, or there's other possibilities, and one of them would be a Class 3 license would allow a single family of 5 to live there without being in violation of the license. So maybe that's what happened for the first 16 years, and then they moved out. So that's the first assessment we have to make. And then we have to find out if that's the case and the family did move out, how did it happen? And what I mean by that is, so if the family sublet, for example, to somebody without the landlord's knowledge, well, then under the International Property Maintenance Code, which the City of East Lansing has adopted, we have less remedies in enforcement actions because it's a knowledge. It's did the landlord know or should have known kind of a thing. If it was just the landlord, then we still have the same enforcement options. But before that, we back up and we say, okay, so pursuant to 1004.7 of the property code, we have to look and say, all right, we're going to send a letter to the landlord, and we're going to tell them what's going on. And I think this is the first step all the time. I told you before that I'm in court a lot and I litigate a lot, but I don't want you there. And I don't think it's not cost effective. And again, what message are we sending? Is this a good property owner? We have to look into that. Does she own other properties in the city of East Lansing? What investor statement are we making if we jump to litigation? You know, they're going to talk, and some friends going to say, hey, I'm thinking about investing in East Lansing. How's the city? We want the message to be, hey, if you're good to them, they're good to you. So we talk to them. We'll send them that letter and say, not a demand letter, but hey, we noticed this happened. Can you meet with us and talk? So then in that conversation, we'll learn. And then pursuant to 1010.1, we'll decide, all right, they did know or they didn't know. Then what do we do now? Well, I think the easiest thing, if there are certain qualifications are met, would be to move the Class 3 to a Class 4 license, because the Class 4 license would allow 5 people. But you can't do a Class 4 license as an initial application. So it would have to meet the requirements in the zoning code, and then if so, we can renew it as a Class 4 license. If that is the case, then there's only one thing left, and that's the risk factors. And I think that it's probably that way because I believe a family of 5 is going to use different utilities and heat and everything different than 5 adults, especially 5 college adult students. So I think that we have to have an inspector out there and say, hey, are there any health and safety concerns if we move this to a Class 4 license? And if there aren't any, then we just avoided litigation. And if we have to go to litigation, we do, and we can lay out that plan. But I think that would be the best approach in that scenario.
By city charter, all contracts must be approved by the city attorney. This is a frequent requirement. Please tell who will be involved from your firm in the review and how will it be billed?
So that would be myself and Chelsea Leonard, who's over here as well. We would be the primary ones reviewing, conducting. We bill at a 0.16 minute incremental value for our contracts. We review them. You know, the reason we've brought a team here today is because we all kind of carry our own expertise. I mentioned Cheyenne here before. Is the head of our marijuana department. If we have a contract coming in that's going to involve marijuana, I'm going to want her involved. She's heavily involved at the state level, the state bar level, of all things marijuana. And so, you know, I'm going to want her having some assistance on that. With that said, I anticipate that I will be the only one involved with that, again, with Chelsea assisting me going through that process. I know the second part of the question is concerns with regards to costs. I pride myself as much as I can is saving my client costs. I'm frequently telling my clients something that I'm pretty sure they don't hear from any other attorney, and maybe isn't the best approach that I should tell the council as we're going into negotiation. I really don't want to take your money, because as much as possible, I would like you to keep the money and do what you can with it. I want to do my job as quickly and effectively and efficiently as possible so that we can make sure we're getting to things that actually matter. Not saying that contract review doesn't matter. It's very important we understand what's contained within them. But I want to do things as quickly and efficiently as possible so that we can make sure we're best using our funds and your resources to make the city a better place.
Thank you.
I would add just real quickly, Tim and I would also be reviewing all of the bills. So if there's multiple people working on a bill and we feel that it was unfair, that, you know, hey, this took half time longer because we had too many people looking at it, we're going to credit that.
Which we do right now.
Yep.
We have the team approach because we want people to have the best advice.
Okay.
You're going to combine 12 and 13.
Yes, okay, sorry. I slipped to that page, one question too early. What is your experience handling property tax appeals on behalf of the municipality, and have you handled any major trials in front of the tribunal?
So no tax tribunal experience from the city side, but tax tribunal experience from the other side. It actually started personally when I bought some property in Grand Ledge with some other people for rental properties. And actually that's probably the biggest that I see. So then I've done other tax tribunal work. And you don't see, at least I haven't in my experience, as many residential people challenging as you do investment owners that come in and say, hey, look, I'm looking at my capitalization rate, and the capitalization rate, according to X proposal, doesn't match up. And what my experience, at least recently, has been, especially in this real estate market, is the tax tribunal is very good with, well, but here's the price you bought it at, here's the price that 5 other properties are around the area. This assessment is fine, there's nothing wrong with it. So, I mean, I have the other experience, I don't have the other, that's for the city experience. And I have actually done no full trials at the tax tribunal.
You guys were not interested in the prosecution side of us. We really wanted to talk about this.
If you want to talk about it, I mean, we have Iana here, but I also want to be very clear. I have had conversations with Mr. Easterly about it. He is the current city attorney, and I mean,
You're prepared to do it.
we're prepared to do it. We're prepared to do it. We're prepared to do it with them. We're prepared if it's a if you want a global. If you want a global.
I thought you started the presentation saying you were only bidding on the non-prosecutorial stuff.
That's the only bid we did. That's correct, George. I'm saying.
So the only documentation we have from you, bid-wise, is on the non-prosecutorial.
Correct.
Jesse got excited.
Thank you.
That's a no-go. That's a no-go.
But I was saying that at the point that if Mr. Easterly does get the contract and he needs assistance, he and I are in discussions where we could give assistance.
So you're kind of like one of the guys we saw before, who said we'll take whatever we can get. No offense to you.
No, that's correct.
Well, I've dealt with Iana, and I can tell you that she is a force of nature and law. And I'm surprised it's only 80 trials, because she was every woman in all of those courts when I was down there. It's been some time, so she's got more experience now. So really, Iana, just list the first 100 or 50 case numbers and defendants, and by all means, just rattle them off. But there's a dream team factor in this.
I don't really think we're here to make comments on the various people and bids and all that stuff.
Before I lose track, though, we're already open questions from council. Dan has hers.
Yeah.
She's always
So just going through the attorney identification, I think there's 2 peoples whose are missing. Is there any way you all can submit those? So under the bios that were submitted or attachment 2, it seems like of your team, there's 2 people that aren't included, and same with the.
Sure. I'm going to presume, knowing the file, it's Ann Neal and Tyler Burke.
You're correct.
And we will get those to you.
Okay.
Absolutely.
All right. And so, clarification on who's managing partner? Who's a managing partner?
Of the firm?
Yes.
I'm the owner and managing partner.
And you had mentioned you're not going to be really involved with
I am going to give the backing to my team.
as much, yeah.
Yeah.
And it's the hourly rates that where I'm going with this. We're
Correct.
trying to understand that. So the next people are senior attorneys.
Correct.
And that's really kind of the rates that we need to look at.
Correct, but Councilwoman, everything's open to negotiation in the end.
All right. And my last question is just, some of you mentioned being in Grand Rapids, some are in Okemos. So any mileage charges or anything like that?
No. Nope. And I drive a Prius, so it's like good for the environment.
You'll fit right in.
Thank you.
Is there any other open questions?
Thank you.
I'm good. You guys have any
Closing comments?
summary?
Yeah.
I just want to, if we have a chance to have this contract, I want to assure the council that we will put everything in this, just like we do in every case. But I'll use the tax tribunal as an example. There might not be expertise with the people here. I actually have expertise in that area because I have a master's law in taxation, and I did a lot of that. I just don't do it right now. I have no problem getting somebody else, another attorney if need be, to come assist the team. I have no problem doing that. That's a benefit of owning your own firm.
I just want to make a clarification on something, because I'm not noticing a lot of public sector experience, but just want to be clear that our city attorney sits with us 2 of our meetings per month. Meetings typically start around 7 and maybe end in a couple of hours. I make gambles and bets on the time.
So it's more than a couple of hours.
Yeah, right. So just hopefully, is that okay with you all and the work that you do?
Yes.
Okay.
And just on that point real quick, so this all started, I'm a good friend of Mr. Easterly. We went to law school together. So we were just talking randomly one day and it came up. I'll speak to this because Mick sometimes is humble, but Mick has a really great desire to help the community. And I think that anyone in this community knows that he's done a lot, not just legal work, but monetarily to support the community. This was another way of saying, you know what, we can start getting more involved in this community. And, you know, if we are awarded the contract, we're going to see, you know, that we're going to restructure things a little bit to make that a priority. So we absolutely consider all of those things as very important.
Thank you.
Thank you very much. Thank you very much for your time.
Thank you.
Thank you.
And then you also have
Rather than shaking everybody's hand during COVID, I'll just say thank you. I don't know, law school, I'm one of the people.
My younger sister. So good to see you again. Yeah, that's. Okay, we're still. Sorry about that. No, it's
Trust me, you don't want to hear about it.
Oh, no, I do. So wait, so the boy has started, what house? I still live in
Pearl Street.
You are not talking about it.
No, right down the road. We use that one as an example, so why would there be?
Somebody's got to go chase them.
I had a 4-hour extension during my time.
maybe 10. Yes, I bet you did. Well, you're going to have that here, so if you end up with us.
Oh, yeah.